toda la bandera.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Chair now recognizes himself for an opening statement. The fix is in. Even with the face-saving indictment last week of Hunter Biden, everyone knows the fix.
Todo y el encausamiento de Hunter Biden la semana pasada, todos sabemos que la componenda ya está montada. Por 4 años y medio se ha estado investigando a Hunter Biden. David Weiss lo ha estado investigando. Y hay un número limitado de personas a las que se puede entrevistar. Y en las entrevistas no se pudieron concretar. Una investigación que ha limitado las tentativas de interrogar al señor Biden, dándole aviso anticipado, notificando a los abogados de un potencial allanamiento en una investigación del señor Weiss, donde le han contado 3 historias diferentes al Congreso en 33 días. El 7 de junio, David Weiss dijo que tenía la autoridad para determinar cuándo, cómo y dónde presentar cargos. 23 días más tarde, le dijo a esta comisión: yo solo puedo presentar cargos en mi distrito, el distrito de Delaware. Y para confundir más las cosas, el 10 de julio, le dijo al senador Graham: yo no tengo estatus de fiscal especial. Yo dependo del Departamento de Justicia. La investigación del señor Weiss, quien negoció un arreglo que no fue aceptado por la Corte, un acuerdo tan ridículo que el juez preguntó: ¿hay algún precedente para acceder a no procesar un delito que no tenga nada que ver con los cargos? La respuesta: yo no sé de ningún caso, su señoría, dijo el abogado del Departamento de Justicia. Fue tan ridículo que el juez preguntó: ¿se ha visto un acuerdo como este, con condiciones tan amplias, que cubre delitos en un caso diferente? La respuesta del abogado: no, señor, no lo hemos visto. Una investigación del señor Weiss que tenía un acuerdo que fue rechazado, y de acuerdo con el New York Times, había un arreglo previo, aún mejor, donde el señor Biden no tenía que asumir culpabilidad por nada. 4 años y medio más tarde, todo eso, y ahora tenemos un fiscal especial. Un fiscal especial, ¿y a quién escoge el secretario de Justicia? A David Weiss, el tipo que permitió que todo eso pasara. Pudo haber escogido a cualquiera. Pudo haber escogido a cualquiera dentro o fuera del gobierno, pudo haber escogido a secretarios de justicia, exfiscales especiales, pero ¿a quién escoge? A el único tipo que sabe que va a proteger a Joe Biden. Escoge a David Weiss. Y esto fue lo que dijo el secretario de Justicia en su anuncio de la designación de David Weiss como fiscal especial. Tengo confianza en que el señor Weiss va a cumplir sus responsabilidades de manera imparcial y urgente. Urgente, con todos los testigos con los que hemos conversado, todos, el señor Chaplin, el señor Ziegler, los agentes del FBI, todos han dicho lo mismo, que aquí había de todo menos urgencia. El FBI decía que estaban frustrados con el ritmo de la investigación, la señora Holly dijo lo mismo, y por supuesto los agentes del Servicio de Rentas Internas decían que la investigación era muy lenta. Imparcial, limitaron el número de testigos que se podían entrevistar, le informaron de las combinatorias a la defensa, y todo esto es apenas la mitad de la historia. Hay una investigación para proteger al presidente Biden y otra para atacar al presidente Trump. El Departamento de Justicia tiene ambos lados de la ecuación cubiertos. Vean esto. En el verano del año pasado, el Departamento de Justicia le pidió al presidente Trump que entregara cajas de documentos. Él lo hizo. En el proceso, el presidente Trump descubre 38 documentos adicionales. Le informa al Departamento de Justicia. Al día siguiente, el FBI regresa a la casa y él se los entrega. Y le dicen que entregue todas las cajas, que las ponga en un lugar protegido. Él lo hace también. Todo lo que le piden que haga, lo hace. ¿Y qué hace el Departamento de Justicia? El 8 de agosto del año pasado, allanan la casa del presidente Trump. Y de acuerdo con un agente del FBI, con Steven Deitwane, el director adjunto a cargo de la oficina de Washington, dice que la búsqueda se apartó completamente de los protocolos establecidos. Cuando entrevistamos al señor D'Antuano, dijo, primero que nada, la oficina de Miami no hizo la pesquisa. Envió gente desde Washington. Dijeron que no había un fiscal asignado al caso. Esto lo estaba haciendo Washington. Jay Brad estaba en el equipo del fiscal especial. Dijeron que el FBI no obtuvo la aprobación antes de hacer la búsqueda. Y el señor D'Antuano nos dijo que él había recomendado que cuando el FBI fuera a la residencia del presidente Trump, que contactaran a sus abogados, esperaran que llegara e hicieran la búsqueda juntos. El Departamento de Justicia, por supuesto, dijo que no. ¿Y quién es el fiscal a cargo? Jack Smith, el tipo que hace unos años está buscando maneras de procesar a estadounidenses, utilizando el servicio de rentas internas, tratando de ir en pos de las víctimas de un gobierno que estaba utilizando como arma el servicio de rentas internas. Jack Smith, el mismo que vio su caso revertido en la Corte Suprema en una decisión unánime. Ese es el tipo que el secretario de Justicia de los Estados Unidos escoge como fiscal especial. Y uno se pregunta por qué 4 de cada 5 estadounidenses piensa que en este país hay estándares de justicia. Señor Garland, anticipo que habrá múltiples preguntas sobre estas investigaciones. Más adelante espero que reciba preguntas sobre muchas otras inquietudes que tiene el pueblo estadounidense con el Departamento de Justicia. Memorandos de la Junta Escolar, el tratamiento de católicos, tildando a activistas católicos como extremistas, decisiones del Departamento de Justicia y otras entidades censurando la libertad de expresión de los estadounidenses y la aplicación de las leyes FISA, y cómo este proceso está siendo objeto de abuso y violación de los derechos a la privacidad del pueblo estadounidense. Los estadounidenses piensan que en nuestro país hay una aplicación desigual de la justicia. Y lo piensan porque ese es el caso. Y eso tiene que cambiar. Tiene la palabra.
Thank you, Mr. Chairman. Mr. Chairman, at the outset, let me make 2 comments. One, just about every assertion you made in your opening statement has been completely refuted by witnesses who have testified before this committee.
Todas estas cosas que usted dijo en su declaración inicial es algo que ha sido refutado por los testigos en este caso.
That people accused of simple gun possession while under the influence of a drug.
A una persona acusada de posesión de armas bajo influencia de drogas, el arma no se utilizó para cometer un delito. Esto es algo que rara vez se procesa, pero sí en el caso de Hunter Biden. Señor presidente, una de las responsabilidades fundamentales de esta comisión es supervisar al Departamento de Justicia. Tenemos que asegurar que el Departamento de Justicia utiliza el enorme poder que se le ha conferido de manera justa e imparcial, respetando los derechos humanos de todos los estadounidenses. El fiscal general de los Estados Unidos, el secretario de Justicia, es el garante de los derechos de todos los estadounidenses y procesa toda clase de delitos contra la seguridad nacional, delitos sobre drogas, delitos ambientales y más. Todo esto cae bajo su jurisdicción. Por eso, regularmente pedimos que comparezca ante esta comisión para hablar del trabajo que hace el departamento por el bien del país. Así es como aseguramos que el departamento responde al pueblo estadounidense. Si fuera por los republicanos, no se escucharía de nada de esto. No se escucharía nada sobre el terrorismo interno y lo que está haciendo el Departamento de Justicia. No se escucharía lo que se está haciendo para evitar la violencia armada y los crímenes de odio, de lo que se está haciendo para contrarrestar los esfuerzos de Rusia, China y otros de interferir en nuestras elecciones. Los republicanos de MAGA están torpedeando este proceso y están utilizando su poder para montar una treta política sobre otra, desperdiciando dinero de los contribuyentes en investigaciones sin fundamento del presidente Biden y su familia, tratando de lanzar un juicio político, tratando de desviar la atención de los problemas legales de Donald Trump. Han luchado incansablemente para evitar que se investiguen las tentativas de manipulación de los estadounidenses en redes sociales, la interferencia en litigios criminales, el intento de amedrentar a las autoridades, Han dado a conocer los nombres de testigos en aras de sus metas políticas, lo que ha llevado a amenazas contra estos testigos y sus familias. Numerosas instituciones han incurrido en millones de dólares en gastos legales tratando de satisfacer las ridículas solicitudes de información y transcripciones. Esto se está haciendo sin ningún esfuerzo serio para obtener información. Están lanzando ataques infundados contra cualquier fiscal que presente cargos contra Donald Trump o los insurrectos del 6 de enero. Tratan de desacreditar a los investigadores que no se enfrentan a los adversarios políticos de Trump. Han apoyado a quienes atacaron el Capitolio el 6 de enero tratando de subvertir unas elecciones legales. Un proceso ilegal como el robo de material confidencial y la incitación a la violencia. Y en medio de todo esto, en lugar de tratar de unificar al país o de resolver los problemas que nos afectan a todos, han tratado de con propósitos políticos cínicos. Esa es su meta, la división. Quieren dividir a este país y que nuestro gobierno parezca que está descalabrado, porque allí es donde ellos prosperan. Así que hoy le imploro al público que vea a través de todo esto. Sin duda van a escuchar una sarta de acusaciones infundadas y teorías conspirativas. Se va a hablar de supuestos denunciantes, desacreditados o refutados. Habrá ataques contra las autoridades. Les van a decir que los cargos contra Donald Trump son parte de una conspiración, a pesar de la evidencia de los crímenes de Donald Trump. Y van a atacar al fiscal Weiss, quien fue nombrado, no olvidemos, por el mismo Donald Trump, por no ser suficientemente firme con Hunter Biden. Los republicanos han hecho esto durante años. Desacreditan a cualquiera que no sirva a sus propósitos políticos. Y lo más vergonzoso es que en esta sala, igual que en la Cámara, los colegas republicanos se insultan, pero pudiéramos estar trabajando juntos para poner a la gente estadounidense. Hay estadounidenses que están muriendo por la violencia armada, miles en lo que va de este año. Las armas son la principal causa de muerte de niños entre 1 y 17 años, más que los accidentes automotrices. El extremismo y el nacionalismo están en aumento. Estamos viendo cómo grupos supremacistas aparecen por todo el país. El antisemitismo ha alcanzado un nivel sin precedentes. Entes como Rusia, China, Corea del Norte e Irán tratan de influir en nuestras elecciones. La retórica política está llevando a que aumenten las amenazas contra funcionarios públicos. Nuestro sistema inmigratorio necesita una reforma desesperadamente y ha habido amenazas de extremistas. El fentanilo inunda nuestras calles y envenena a nuestros chicos a un nivel sin precedentes. La lista suma y sigue. Y nosotros en esta sala tenemos la posición de hacer algo al respecto. En realidad tenemos la obligación de hacerlo. En concordancia con el juramento, cuando fuimos juramentados como miembros del Congreso. Podemos trabajar con el Departamento de Justicia y el secretario Garland para atender problemas sustanciales que enfrenta el pueblo estadounidense. Pero en lugar de eso, los republicanos van a usar el tiempo hoy para hablar de teorías desacreditadas y de la computadora de Hunter Biden. Lo van a hacer porque les preocupa más Donald Trump que su propio electorado. Espero que mis colegas sean razonables y que al menos intenten trabajar de buena fe con el secretario de Justicia. Lamentablemente, en el otro partido, la buena fe parece ser escasa. Gracias, señor secretario, gracias por su testimonio y gracias de antemano por su paciencia. Cedo la palabra. Todas las declaraciones iniciales se incorporarán al expediente. Le damos la bienvenida al secretario de Justicia, Merrick Garland, juramentado el 11 de marzo de 2021. Le damos la bienvenida. Le agradecemos por haber venido. Vamos a tomarle juramento. Por favor, levante su mano derecha y póngase de pie. Jura, so pena de perjurio, que el testimonio que va a dar es la verdad, toda la verdad, a su leal saber y entender. El testigo ha respondido afirmativamente. Gracias, puede tomar asiento. Su testimonio será incorporado la totalidad en el expediente. Le pedimos que nos dé un sumario. Usted lo sabe, ha estado aquí antes. Gracias por estar aquí. Puede proceder con su declaración inicial. ¿Está funcionando? Gracias. Buenos días, presidente Jordan, señor Adler, distinguidos miembros de esta comisión. Gracias por la oportunidad de comparecer ante ustedes en nombre de los más de 115.000 empleados del Departamento de Justicia. Desde la fundación del Departamento de Justicia, ha tenido la tarea de hacerle frente a algunos de los retos más apremiantes del país. Hoy estamos manejando asuntos de interés público que tienen suma relevancia para nuestra democracia. Se ha dicho mucho del Departamento de Justicia, de quiénes somos, de lo que hacemos, de cuál es nuestro trabajo y cuál no es nuestro trabajo, y sobre por qué hacemos este trabajo. Quiero darles algo de claridad. Primero que nada, ¿qué somos? El departamento lo integran más de 115.000 hombres y mujeres que trabajan en todos los estados y comunidades del país y alrededor del mundo. Incluyen el FBI, la DEA, ATF, el Servicio de Alguaciles, quienes arriesgan sus vidas para servir a sus comunidades. Son fiscales y personal de fiscales que trabajan para que se cumplan nuestras leyes. La gran mayoría son servidores públicos de carrera, lo que significa que no han sido designados por ningún presidente de ningún partido. Segundo, quiero aclarar cuál es el trabajo del Departamento de Justicia y sobre lo que no es. Nuestro trabajo es velar por la seguridad de nuestro país. Eso incluye trabajar con departamentos de policía y comunidades del país para enfrentar el crimen violento. De hecho, hoy estamos anunciando los resultados de una operación del Servicio de Alguaciles realizada junto con autoridades estatales y locales para ir en pos de fugitivos violentos, y esto resultó en 4.400 arrestos en 20 ciudades en solo 3 meses. También tenemos la tarea de combatir los cárteles de drogas que están envenenando a nuestros ciudadanos. El viernes pasado logramos la extradición de Ovidio Guzmán López, líder del cártel de Sinaloa. Lo trajimos de México a Estados Unidos. Él es el hijo de El Chapo y uno de más de 12 miembros de cárteles que hemos encausado y extraditado a Estados Unidos. Nuestro trabajo incluye buscar justicia para los sobrevivientes de explotación infantil, tráfico humano y tráfico sexual. E incluye proteger instituciones democráticas como esta, haciendo que respondan todos aquellos responsables por el ataque al Capitolio el 6 de enero. Nuestro trabajo también es proteger los derechos civiles. Eso incluye proteger nuestras libertades como estadounidenses, la libertad de culto y de pensamiento, de expresión de nuestras ideas y creencias. Incluye proteger los derechos de todos los ciudadanos elegibles para votar y de que esos votos sean contados. Incluye combatir la discriminación, defender los derechos reproductivos consagrados en la ley y procesar crímenes de odio y disuadirlos. Y nuestro trabajo es hacer que se cumpla el imperio de la ley. Esto significa que aplicamos las leyes por igual a todos. No hay leyes para los poderosos y otra para los que no lo son. Una para los ricos y una para los pobres, para los demócratas y otra para los republicanos, o reglas diferentes de la raza, origen étnico o religión de un individuo. Nuestro trabajo es buscar justicia sin temor o favoritismo. Nuestro trabajo no es hacer lo que es políticamente conveniente. Nuestro trabajo no es recibir órdenes del presidente, del Congreso o de nadie respecto a quién, cómo o cuándo se debe investigar. Yo no soy el abogado, yo no soy el fiscal del Congreso. El Departamento de Justicia trabaja para el pueblo estadounidense. Nuestro trabajo es en pos de los hechos y eso es lo que hacemos. Todos reconocemos que esto conlleva escrutinio, críticas y supervisión. Esto es importante dada la gravedad de los temas frente al departamento, pero el ir en pos de servidores públicos individuales es algo peligroso. En momentos en que aumentan las amenazas contra estos servidores públicos y sus familias, no nos vamos a dejar intimidar. Vamos a hacer nuestro trabajo sin aceptar influencias externas y vamos a defender nuestra democracia. Quiero explicar por qué actuamos de esta manera. El Departamento de Justicia fue establecido después de la Guerra Civil, en medio de la reconstrucción, con la tarea fundamental de llevar ante la justicia a los supremacistas blancos y otros que aterrorizaban a los estadounidenses negros para que no ejercieran sus derechos civiles. El trabajo del Departamento de Justicia, entonces y ahora, es hacer realidad la promesa fundacional de nuestra democracia, que la ley nos va a tratar a todos por igual. Esa promesa es también la razón por la que estoy aquí. Mi familia huyó de la persecución religiosa en Europa Oriental a comienzos del siglo XX. Mi abuela era una de 5 hijos, nació en lo que es Belarus. Ella vino a Estados Unidos. 2 de sus hermanos no pudieron llegar, murieron en el Holocausto. No hay duda de lo que le pudo haber pasado a mi abuela. Se puede vivir sin temor. Estamos pagando la deuda que tiene mi familia con este país. Este ha sido el foco de toda mi carrera profesional. Por eso sirvo en el Departamento de Justicia. Lo hice bajo 5 secretarios de justicia, bajo gobiernos republicanos y demócratas. Por eso he pasado más de 25 años asegurando el imperio de la ley como juez. Y es por eso que dejé un nombramiento vitalicio como juez y regresé al Departamento de Justicia hace 2 años y medio. Por eso estoy hoy aquí. Estoy ansioso por responder a sus preguntas. Gracias, señor secretario. Estados Unidos es el país más grande que haya existido y a nosotros nos preocupa esa aplicación equitativa de la ley. Comencemos con el caballero adicional, el señor Thompson. El imperio de la ley distingue a nuestro país, pero el señor Weiss no ha hecho eso. Usted ha permitido que por eso 65% de las personas en el país no tienen fe en el Departamento de Justicia, no confían en el Departamento ni en usted, porque todos los días están viendo un Departamento de Justicia politizado y un doble estándar de justicia. Vemos cómo actúan de manera enérgica contra el rival político del presidente Biden, el señor Trump, pero al mismo tiempo al hijo del presidente le dan tratamiento preferencial, y eso es evidente. Quiero concentrarme en esta investigación de la familia Biden. Tenemos muchas preguntas sobre ese tema. Directamente al grano. ¿Alguien en la Casa Blanca le ha dado instrucciones a usted personalmente o a algún alto funcionario del Departamento de Justicia respecto a cómo manejar la investigación de Hunter Biden? No. ¿Ha tenido usted contacto personal con alguien en el FBI sobre la investigación de Hunter Biden? Bueno, no recuerdo la respuesta a esa pregunta, pero el FBI trabaja para el Departamento de Justicia. Discúlpeme. ¿Usted no se acuerda si habló con alguien en el FBI sobre la investigación del hijo del presidente? No creo haberlo hecho. Yo le prometí al Senado, cuando vine para la confirmación, que mantendría al señor Weiss en posición y no iba a interferir con sus investigaciones. Yo he cumplido esa promesa. ¿Ha tenido usted contacto personal con alguien de la oficina de Baltimore sobre el caso de Hunter Biden? No. David Weiss le dijo al senador Lindsey Graham: he tenido conversaciones con autoridades del departamento respecto a un potencial nombramiento, lo que me permitiría encauzar un proceso fuera de mi distrito. sin tener que trabajar con el fiscal general. ¿Con quién habló el señor Weiss? Yo no voy a hablar de los procedimientos internos del departamento. Debe hacerlo, esto es importante. Tenemos responsabilidad de supervisar su departamento. Si es apropiado que el señor Weiss converse con el departamento, hemos dejado en claro que si él quiere presentar un cargo en cualquier jurisdicción, puede hacerlo. La forma de hacer esto es obtener una orden firmada por el secretario de Justicia. Hemos prometido que lo haríamos y él dijo que entendía que podía hacerlo. ¿Puede hablarnos de algún informe o discusión que usted ha tenido personalmente con el señor Weiss respecto a alguna investigación federal de Hunter Biden? Reitero, yo le prometí al Senado que no interferiría con esto. Bajo juramento, su testimonio es que usted no ha tenido ninguna conversación con el señor Weiss sobre este asunto. Bajo juramento, mi testimonio es que yo le prometí al Senado que no interferiría en la investigación. No tengo la intención de hablar de conversaciones internas del Departamento de Justicia, si han ocurrido o no. Así que su testimonio es que no nos va a decir si ha hablado con el señor Weiss. Mi testimonio es que yo le dije a la comisión que no iba a interferir. Dejen claro que el señor Weiss podría presentar los casos que considerara pertinentes. Permítame, por segunda vez, ¿sabe usted qué funcionarios del FBI han venido a esta comisión y han hablado de un complejo proceso burocrático que tiene que pasar al señor Weiss para presentar cargos? No lo sé, pero no es cierto. No hay nada de complicado en el proceso. Entonces, ¿están mintiendo? ¿Esto es una mentira? Su descripción del proceso es una opinión, no es un hecho. El señor Weiss es el fiscal principal del caso de Hunter Biden desde 2018. El señor Weiss es el que estuvo a cargo desde 2018. Ha estado a cargo desde que fue nombrado por el presidente Trump. ¿Por qué el Departamento de Justicia ha arrastrado esta investigación por tanto tiempo? Realmente se requieren años para determinar si Hunter Biden le mintió al gobierno. El señor Weiss es un fiscal de larga data. Fue nombrado por el presidente. Yendo a la pregunta, ¿es eso normal? ¿Debe una investigación tomar tanto tiempo? Le estoy respondiendo, deme la oportunidad de hacerlo. A él se le encomendó esta investigación bajo el gobierno anterior. Él ha continuado, él sabe cómo hacer una investigación. Y yo no he interferido o tratado de evaluar este proceso, porque esa fue la promesa que le hice al Senado. Los denunciantes nos hablaron de problemas de conducta en el Departamento de Justicia sobre el tratamiento preferencial a Hunter Biden. ¿Pidió usted que se investigara ese asunto? Hay procesos establecidos para que los denunciantes presenten sus denuncias. Yo defiendo este proceso. Tenemos un inspector general, una oficina de responsabilidad profesional. Esos son los canales para... Se me acaba el tiempo, sobre la palabra. Tiene la palabra el señor Nadler. Señor secretario, gracias por estar hoy aquí. No es un secreto que algunos de mis colegas del otro partido han amenazado con cerrar el gobierno a menos que el FBI y el Departamento de Justicia tengan un recorte de fondos. Donald Trump dijo que había que abolir al FBI. Señor secretario, ¿cuál sería el impacto de este retiro de fondos? Si se le quitaran los fondos al FBI, el país quedaría al descubierto ante influencias malignas del Partido Comunista de China, los ataques de iraníes contra ciudadanos estadounidenses, los intentos de asesinar a exfuncionarios, las agresiones de Rusia, los ataques cibernéticos de Corea del Norte, crímenes violentos en los Estados Unidos que son combatidos por el FBI, actos de espionaje, extremismo y violencia, gente que ha atacado a nuestras iglesias, sinagogas y mezquitas y que han matado a individuos por motivos raciales. No puedo imaginarme las consecuencias de quitarle los fondos al FBI. Esto sería catastrófico. Hablemos de la investigación del señor Weiss y de su autoridad para realizar una investigación sin interferencia, como lo considere necesario. Usted le dijo a la Comisión de Asuntos Judiciales que David Weiss tenía plena autoridad para adelantar esta investigación sobre Hunter Biden. ¿Era eso cierto? Así es, el señor Weiss tiene absoluta autoridad para adelantar esta investigación como lo desee. Y el señor Weiss lo ha confirmado ante esta comisión. Él puede presentar cargos en jurisdicciones fuera de Delaware si es necesario, ¿correcto? Le aseguré al señor Weiss públicamente que él tendría la autoridad para presentar cargos fuera de Delaware si lo consideraba pertinente. ¿Eso sigue siendo válido? Así es. ¿Ha habido algún momento en esta investigación en que el señor Weiss no haya podido presentar cargos fuera de Delaware? En base a mi autoridad le prometí que podría hacerlo. Esto es evidente en las cartas intercambiadas con la comisión y en mi testimonio previo, para que el fiscal o el fiscal especial presente cargos. Yo tengo que firmar un documento en la sección 515 que permite presentar cargos fuera de jurisdicción. Yo prometí hacer lo que fuera necesario para que el señor Weiss pudiera presentar cargos fuera de su jurisdicción si lo consideraba pertinente. Asumo que usted entiende que el señor Weiss sabe que puede presentar cargos fuera de Delaware. El señor Weiss lo dijo en la carta que le envió la comisión. Gracias. ¿Alguna vez se hizo o dijo algo que pudiera reflejar dudas si podía presentar cargos? Sus cartas indican que él nunca me pidió ser fiscal especial, que él entendía el proceso para solicitar la firma del formulario de autorización. Ha habido acusaciones que el caso de Hunter Biden está siendo manejado como un sistema de justicia dual. ¿Qué dice usted al respecto? El Departamento de Justicia trata a todos por igual, al margen de su partido, origen étnico, condición económica. Todos son tratados igual. Hay gente que puede no entender por qué algunas investigaciones se hacen de cierta forma. Por eso tenemos las cortes y todas las explicaciones respecto al caso del señor Weiss se darán a conocer cuando concluya su periodo como fiscal especial, cuando presente un reporte público que he prometido que daría a conocer hasta donde sea consistente con la política del departamento para explicar su decisión de presentar cargos o no. ¿Qué impacto tienen las acusaciones de miembros del Congreso? Acusaciones infundadas contra funcionarios del gobierno. ¿Esto les hace más difícil hacer su trabajo de manera efectiva? Los miembros del Departamento de Justicia son gente fuerte que entienden que su trabajo es hacer lo correcto al margen de cualquier presión. ¿Qué es lo peligroso? No hablo de la comisión. Lo que es peligroso es cuando cualquiera trata de ir en pos de un fiscal en particular o un agente del FBI. Y sabemos, de hecho, que ese tipo de ataque focalizado lleva a amenazas. Esta es una preocupación general, no en casos individuales. Se me está acabando el tiempo. Tiene la palabra el caballero de Carolina del Norte. Señor secretario, usted es la única persona que puede asegurar que el señor Weiss tiene toda la autoridad que necesita. ¿Es así? Soy la única persona que puede asignar a un fiscal especial la autoridad de firmar estas autorizaciones. Pero la autoridad última es suya. Usted no recibe órdenes del presidente sobre estos temas. Usted es quien decide lo que hace el Departamento de Justicia. Como dije al comienzo, yo prometí que él podría presentar cualquier caso que desee y he cumplido.
Interact with him sufficient to ensure that he knew he possessed that authority, or that you would see to it that he got
Usted interactuó con él lo suficiente para hacerle saber que él tenía esa autoridad. Creo que no hay duda. Él ha escrito 3 cartas a esta comisión indicando que entiende que tiene esa autoridad. ¿Y está usted consciente que un investigador del FBI dio testimonio público que el señor Wise dijo que no tenía esa autoridad, que él no decidía. ¿Sabía usted eso? Yo sé del testimonio, yo no estuve presente cuando se hizo la declaración. El señor Wise, quien estaba presente, dijo que él tenía la autoridad, sabía que la tenía. Después de eso, usted decidió nombrarlo fiscal especial, cosa que no había hecho hasta entonces. El señor Wise dejó claro que él no me había pedido ser un fiscal especial, sino hasta el mes pasado, y el mes pasado procedí. ¿Hubo falta de información que le impidió actuar más temprano? Wise no pidió eso. Entiendo que no lo pidió, usted lo ha dicho, pero usted tomó las medidas necesarias para informarse de los obstáculos que estaba teniendo. El señor Wise, como dije desde el comienzo, tiene la autoridad sobre todo lo concerniente a Hunter Biden. ¿Sabe usted que él se vio disuadido en el Distrito de Columbia y en California de proceder como lo consideraba apropiado? Con todo respeto, el señor Wise no dijo que fue disuadido, dijo que siguió los procesos normales del departamento y que nunca le impidieron presentar cargos en otra jurisdicción. Pero, ¿qué cambió? ¿Qué lo llevó a usted a decir que había que nombrarlo fiscal especial? El señor Wise pidió esa autoridad dadas las extraordinarias circunstancias de este asunto y dada mi promesa de que le daría los recursos que solicitara. Yo lo nombré fiscal especial. Así que hasta entonces era una cuestión de sus preferencias, o usted se tomó la molestia de averiguar qué estaba haciendo, bajo qué autoridad y sobre si tenía algún obstáculo. Yo no lo investigué porque yo había prometido no interferir con esta investigación. Una forma de no interferir es no investigar una investigación. Cuando él pidió que lo nombrara fiscal especial, cosa que no se había hecho durante meses, le preguntó a usted qué había cambiado. ¿Por qué necesitaba esto ahora? Él pidió ser nombrado fiscal especial. Yo prometí darle todos los recursos que necesitara y lo nombré fiscal especial.
Justice Department permit statutes of limitations to expire on some of the prospective charges against Hunter Biden for tax violations?
Permitieron que expiraran algunos de los cargos contra Hunter Biden. Yo no sé nada de eso. Esta investigación estaba en manos del señor Wise, quien tenía que hacer las determinaciones que fueran pertinentes. Así que usted no sabía que se había permitido que expiraran los lapsos. Nuevamente, la determinación sobre encauzamientos estaba en manos del señor Wise. Entiendo que usted ha dicho eso y esa es parte del problema. La pregunta es, ¿sabe usted que se permitió que expiraran lapsos cuando este tema está bajo investigación? Los investigadores estaban familiarizados con todas las leyes. No le estoy preguntando cuáles son sus excusas. Le pregunto si usted sabía cuáles eran los hechos. Lo reitero y lo volveré a hacer si es necesario. Yo no he interferido con la investigación. Usted dice lo mismo a otras preguntas. Todos los que estén prestando atención saben que el Departamento de Justicia permitió que expiraran los lapsos. Cualquier abogado que haya practicado entiende la implicación de permitir que los lapsos expiren. ¿Y usted no sabe si esto ocurrió o no? Los fiscales hacen las decisiones que consideran pertinentes. Yo dejé esto en manos del señor Weiss sobre si iba a presentar cargos o no. Eso incluye si se iba a permitir que los lapsos expiraran o no, si había evidencia suficiente o no, si había otros casos con más peso. Tiene la palabra la dama de California. Gracias, señor presidente. Gracias, señor secretario, por estar aquí con nosotros esta mañana. Estamos viendo toda la polvareda que se está armando, pero creo que hay mucha desinformación para confundir a la gente, pero quisiera pedir que se incorporaran en el expediente 3 cartas del señor Weiss, cartas que le envió al Congreso el 7 de junio, el 30 de junio y el 10 de julio. No hay objeción. Él dijo repetidamente que tenía plena autoridad sobre este caso, incluyendo la capacidad de pedir el estatus de fiscal especial si era necesario. El tratar de implicar otra cosa es simplemente falso. El señor Weiss fue nombrado por el entonces presidente Trump. Su decisión fue dejar que este fiscal se hiciera cargo de este proceso sin que usted metiera las manos y que él tomara las decisiones sin interferencia. ¿Es eso correcto? Correcto. Así que la idea de que usted pudiera interferir es completamente errada. Y usted hablaba acerca de su independencia del presidente, pero también su independencia del Congreso. ¿Alguna vez usted ha encontrado instancias donde el Congreso ha tratado de interferir con una investigación del Departamento de Justicia? Voy a ser cuidadoso con la palabra interferencia. Tenemos el precedente del caso Irán-Contras, las sesiones del Congreso, las investigaciones del fiscal especial, en el caso del señor North, cuando se desestimaron cargos. Antes de pasar a otra pregunta que tengo, quisiera incorporar en el expediente el reporte de transparencia de abril de 2023, donde se indica que el proceso para pesquisas del FBI bajo la sección 702, yo quisiera saber, vamos a trabajar con usted. Esta comisión, de forma bipartidista, está preocupado sobre esta base de datos sin tener una autorización. No estamos diciendo que la ley no lo permite, pero vamos a tocar este tema porque mi opinión es que el accesar esta base de datos sin debido proceso, porque esto tiene que ver con individuos extranjeros, es algo inapropiado en cuanto a los derechos de los estadounidenses a la privacidad. Y espero que podamos trabajar con usted al hablar de cuáles son los requerimientos de una autorización para hacer esto. Quisiera preguntarle, como se ha mencionado, la propuesta básicamente es de quitarle los fondos a la policía, al FBI, la propuesta de los republicanos. Me preocupa que si les quitáramos los fondos, como sugiere la mayoría, eso no tendría impacto en los lapsos de expiración. Si el Departamento de Justicia perdiera fondos, el FBI o la policía, como se ha sugerido, ¿qué pasaría con estos lapsos en los casos que están bajo su cargo? ¿Se suspenderían o los criminales saldrían lisos? Yo le diría Como juez, no tengo una respuesta, tendrías que investigarlo. Bueno, yo creo que sí, porque no hay nada en el estatuto que contemple la suspensión de los lapsos porque el gobierno está cerrado o porque la policía ha perdido fondos. Y las implicaciones de un cierre es algo que debemos tomar muy en serio, porque esto permitiría que los criminales escaparan. Se me ha acabado el tiempo, señor presidente, cedo la palabra. Tiene la palabra la presidencia. El señor Weiss tiene la autoridad para presentar cargos en otras jurisdicciones, cito. Esa fue su respuesta al senador, la pregunta del senador Grassley el 1 de marzo. El problema es que ya le habían dicho que no en el Distrito de Columbia. Así que no tenía total autoridad, ¿no es así? Yo tuve una conversación extensa con el senador Grassley. Hablamos de la sección 515 y del proceso. Mi punto es muy simple, señor Garland. Usted dijo que él tenía autoridad total, pero ya lo habían rechazado en el Distrito de Columbia. Y usted le dice al Senado bajo juramento que él tenía total autoridad. Reitero, nadie tiene la autoridad para rechazarlo. Puede negarse a trabajar con él. Usted puede usar cualquier lenguaje que le dé la gana, pero lo habían rechazado. No es lo mismo, es una práctica del Departamento de Justicia. Por eso es que esta pregunta es importante. Es importante porque ustedes dejaron que expiraran lapsos en años críticos en los cargos contra Hunter Biden, cuando él recibía ingresos de Burisma. ¿Por qué es tan importante? A Hunter Biden lo pusieron en Burisma, recibió mucho dinero durante esa época, unos $2 millones. Él no tenía calificaciones para ello, según él mismo dijo. Dijo que lo pusieron ahí por su apellido, por la marca. Número 3. Ejecutivos de Burisma le dijeron a Hunter Biden: estamos bajo presión y necesitamos ayuda. Número 4. Joe Biden va a Ucrania usando el dinero de los contribuyentes de Estados Unidos para presionarlos para que cambien de fiscal. Es interesante que ese hecho se condice con lo que la fuente confidencial le dijo al FBI en un formulario 1023, el mismo que no quiere dejar que el Congreso vea. Eso ya pasó. Mi pregunta es, ¿por qué ustedes dejaron que se cumplieran los lapsos de expiración por esos años que tenían que ver con los ingresos de Burisma? Es otro elemento que es importante, y es que esta investigación la estaba realizando el señor Weiss, alguien nombrado por el presidente Trump. Oportunamente podrán preguntarle esto al señor Weiss y él sin duda va a responderlo en su reporte público que será transmitido al Congreso. Yo no sé la respuesta. ¿Simplemente a los abogados se les olvidó? ¿Fueron descuidados? Espero que esa no sea su respuesta. Usted sabe que no es el caso, porque como dijo el señor Bishop, ya se habían puesto de acuerdo. En algún momento tomaron la decisión explícita de permitir que los lapsos expiraran. Quiero saber quién tomó esa decisión y por qué. El señor Weiss supervisó esa investigación en ese momento y lo ha sido todo el tiempo. Él tomó las decisiones que consideró apropiadas. Se lo podrán preguntar a él. Usted sabe por qué lo hicieron. Todo el mundo lo sabe. Todo el mundo lo sabe. Esos años tocaban al presidente. Una cosa es una acusación por armas en Delaware, eso no toca al presidente, pero lo de Burisma sí, eso repercute en la Casa Blanca. No podemos aceptar eso. Así que se pudo haber extendido, pero dejaron que los lapsos se expiraran. Shepley dijo: el Departamento de Justicia arrastró los pies en esta investigación. Atrasaron la aprobación de todo. Esto ocurrió en Delaware y en el Departamento de Justicia. El agente del FBI dijo: hubiera querido que las cosas se movieran más rápido. Todos los testigos han dicho lo mismo, arrastraron los pies. ¿Por qué? Lo hicieron para permitir que los cargos expiraran, para no tener que tocar el tema de Burisma. Dígame dónde me equivoco. Creo que he tratado de explicar que no conozco los detalles de la investigación. Mucho de lo que usted describe ocurrió bajo el gobierno de Trump. No, no es así. Estamos hablando de los últimos años. Su declaración fue de marzo de este año, el senador Grassley. Lo siento, estaba tratando de responder a su descripción respecto a lo que dijo la gente del Servicio de Rentas Internas. El periodo de 6 años se expiraba bajo el gobierno de Biden. Nuevamente, la explicación de por qué dejaron expirar los lapsos, eso depende del señor Weiss. Una última pregunta rápida. ¿Quién decidió mantener a David Weiss en su posición? El señor Weiss había sido designado y yo prometí. ¿Quién tomó la decisión? Sirven a discreción de la presidencia, ¿no es así? Fue una decisión de Joe Biden. Usted no fue juramentado sino hasta marzo. Es una pregunta fundamental. ¿Quién decidió mantenerlo? El tiempo ha expirado, señor presidente. Estoy esperando una respuesta. Punto de orden. El señor Weiss era el fiscal de Delaware cuando yo asumí mi cargo. Fue nombrado por el presidente Trump. Yo prometí que se le permitiría seguir con la investigación y eso fue lo que ocurrió. Tiene el caballero de Nueva York. Creo que usted citó mal la transcripción, así que pido que se incorpore al expediente la transcripción total. No hay problema. Tiene la palabra la señora Jackson Lee. Gracias, señor presidente. Ninguna de las metas de los republicanos hoy incluyen resolver los problemas que son apremiantes para los estadounidenses. Hay muchas razones, señor secretario, por las que los fiscales deciden no presentar cargos. Una de esas razones es cuando no tienen evidencias para condenar. Ese es el proceso en Estados Unidos. Vamos a tocar estos puntos hoy con usted. Los republicanos han argumentado repetidamente que el Departamento de Justicia y el FBI están conspirando para defender a la familia Biden de críticas públicas y darle a Hunter Biden tratamiento especial en estas investigaciones. Han criticado a las autoridades que han trabajado en este caso todo el tiempo, lo que ha llevado a amenazas contra funcionarios del FBI, miembros de cuerpos policiales que han dicho que defienden. Quiero incorporar transcripciones de dos entrevistas. Le vamos a dar copias. La primera es una entrevista de junio con Jennifer Moore, exdirectora de Recursos Humanos del FBI, quien dijo que el FBI está ofreciendo tantas amenazas que había tenido que establecer una unidad de 10 personas para lidiar con estos casos, que era algo sin precedentes. El segundo elemento es una entrevista de Thomas Subosinski en la oficina del FBI de Baltimore. Esto fue lo que dijo. Me uní al FBI hace 25 años por una razón: ayudar a proteger al pueblo estadounidense y defender la Constitución. He estado en guerras. Mis hijos han sido evacuados de zonas de guerra, de casi guerra. Yo he aceptado todo eso. Estoy concentrado en dos cosas que no son mutuamente excluyentes. Primero, todas las investigaciones deben ser resueltas de manera justa y apolítica. Y segundo, lo más importante y relevante es mantener a la gente a salvo. Nunca hubiera esperado que tendría que tomar motivo de preocupación por la seguridad de mi familia. Para mí, esto es una complicación con la que tengo que lidiar y que me distrae de mis responsabilidades. Así que cuando hablamos de frustraciones y comunicaciones, me frustra personalmente algo que ponga a mis empleados y sus familias en situación de peligro. Sus hijos, sus familias no firmaron para esto. Tengo muchas preguntas, si puede ser breve. ¿Qué ha contribuido a esta oleada de amenazas contra servidores públicos? Como dije al comienzo, hemos tenido un gran número de amenazas contra servidores públicos en los últimos años. Creo que cuando servidores públicos de carrera en el Departamento de Justicia, trabajadores electorales, personal de aerolíneas, cuando son objetos de críticas individuales, esto puede llevar a actos de violencia. Puedo hablar de un ataque contra una oficina del FBI por parte de un individuo enardecido por la retórica política. Esto es inaceptable. La retórica en el caso Biden tiene base en la realidad. La retórica sobre el caso Biden tiene fundamento. No. ¿Y cómo afecta esto a los empleados del FBI y el Departamento de Justicia? Como he dicho antes, los agentes del FBI, los fiscales, entienden que las críticas son inevitables en su trabajo. Van a seguir cumpliendo sus funciones sin miedo o favoritismos, pero la idea de amenazar su seguridad o la de sus familias es detestable. Me imagino que han tomado precauciones para proteger a los agentes y a sus familias. Entiendo que han tomado precauciones para proteger a este personal. Así es. En cuanto a la crisis del fentanilo, quizá usted pueda hacernos un sumario y, en todo caso, el FBI o el Departamento de Justicia están enfocados en la crisis del fentanilo y tengo otro par de preguntas, si nos pudiera hablar de esto. Estoy lidiando con una crisis de tráfico humano. El país está en estado de sitio y tenemos indicios que hay miles de casos donde se está yendo en pos de niños y estos casos no se investigan. Quisiera su comentario y finalmente ¿puede usted enfatizar el trabajo que espero que se siga haciendo para combatir el antisemitismo, los ataques a inmigrantes, afroestadounidenses y latinos? Si puede tocar esos tres puntos, terrorismo doméstico, fentanilo y tráfico humano. Todos estos son problemas horrendos propagados por gente malvada. Estamos combatiendo la crisis del fentanilo de todas las maneras posibles, comenzando con los precursores en China, los laboratorios en México, los cárteles que traen la droga a Estados Unidos, sus redes en Estados Unidos y lo que pasa en las calles de Estados Unidos. Y seguiremos haciendo esto con todos los recursos que nos da el Congreso. El tráfico humano es aborrecible. El Departamento de Justicia ha procesado múltiples casos sobre este tema. La publicación de material sexualmente explícito usando a niños en Internet es algo que seguimos investigando y procesando. Y le pedimos a las redes sociales que retiren este material de sus portales. Me pregunto, señor secretario, ¿alguien en el departamento le dijo al presidente Biden que parara? En el caso de Hunter, ustedes están investigando a Hunter Biden en algunos casos. El presidente Biden lo invita a eventos públicos. Le han pedido que no lo haga. Nuestro trabajo es manejar los casos sin relación con lo que ocurre en el mundo exterior. La respuesta es no. Nadie que yo sepa ha hablado con la Casa Blanca sobre el caso de Hunter Biden. Entiendo. Entonces, Hunter Biden está vendiendo obras de arte para pagar por su arrendamiento en Malibu. $15,000 mensuales. ¿Cómo pueden garantizar que la gente que está comprando esto no lo está haciendo para conseguir el favoritismo del presidente. El Departamento de Justicia investiga alegaciones criminales. Han investigado esto. Alguien que compró una obra de arte de Hunter Biden terminó con un prestigioso nombramiento. ¿No le llama la atención que el hijo del presidente de los Estados Unidos tenga este éxito intempestivo en el mundo del arte? No va a comentar ni va a investigar. Hunter Biden vendió la apariencia de acceso al presidente Biden. ¿Están seguros que ha dejado de hacerlo? Disculpe, no entendí su pregunta. Devon Archer nos dijo que Hunter vendía la apariencia de acceso al vicepresidente Biden. ¿Tiene confianza en que no está haciendo esto? Nuevamente, todo esto cae en la jurisdicción del señor Weiss. Yo no he interferido. Yo no he interferido ni tengo intención de interferir. Ha habido mucho dinero moviéndose en esto. Esto se estableció bajo el gobierno de Trump y se trataba de ir en pos de la influencia del Partido Comunista de China. El Departamento de Justicia de Biden disolvió esa iniciativa. Mi pregunta entonces es, ¿el departamento tiene documentos que indiquen bajo qué criterio se decidió eliminar esa iniciativa? Hemos explicado esto, el fiscal ha dado testimonio ante el Congreso, con gusto les daremos. Díganos en este momento, ¿por qué se disolvió la iniciativa de China? El fiscal dijo que enfrentábamos ataques de naciones foráneas, Corea del Norte, China, Rusia e Irán, y tenemos que concentrarnos en estos ataques. ¿Está usted diciendo que Corea del Norte tiene o entraña el mismo riesgo para Estados Unidos que el Partido Comunista de China? Esto es la impresión que da. Pareciera que los chinos le están dando todo este dinero a los Biden y ustedes eliminan la iniciativa de China. Creo que ustedes lo hicieron porque estaba basado en perfiles raciales. Charles Lieber, un profesor de Harvard, estaba trabajando a favor de China. ¿Sabía usted de los millones de dólares que han pasado por las compañías de Rob Walker y que han llegado a las cuentas bancarias de los Biden? ¿Sabe de eso? Usted ha hecho múltiples preguntas. La primera sobre Corea del Norte. Corea del Norte es un actor peligroso, pero no está a la par de China. ¿Puedo responderle su pregunta? Responda a la pregunta. ¿Sabía usted de los millones de dólares? Yo ya sé cuál es la respuesta. Todo el mundo lo sabe. El riesgo no es igual. Así que pasemos a temas serios. ¿Sabe usted del dinero que pasó por las compañías de Rob Walker? ¿Sí o no? Como he dicho, yo he dejado estos asuntos en manos del señor Weiss. Pareciera que se están haciendo de la vista gorda intencionalmente. Nadie paga un soborno si no espera algo a cambio. Esta iniciativa de China resultó en la condena de un profesor de Harvard, de alguien en Monsanto. Así que estamos trabajando contra los chinos, ellos les pagan a los Biden, y ahora usted me dice que la amenaza es Corea del Norte. Déjeme responderle sobre China. Solo tengo 5 minutos. Usted me ha hecho un montón de preguntas. ¿Han perdido la cuenta de los informantes? Ha expirado su tiempo. Puede responder, señor secretario. China es el adversario más agresivo que enfrenta a nuestro país y estamos haciendo todo lo posible para hacerle frente, para evitar sus interferencias cinéticas y en ciberespacio. Si alguien le hubiera dicho eso cuando usted era juez, no le diría a usted que no respondía. Punto de orden, déjelo responder. Está hostigando al testigo.
The gentleman asked his question before his time expired. The Attorney General did not respond to the gentleman's question. I was hoping he would respond to the question
No respondió a la
about confidential
pregunta,
sources.
esperaba que la
He didn't
respondiera
respond. He didn't
sobre
respond.
las fuentes
I'm sure we're gonna get-
confidenciales,
we're
tampoco
gonna get
respondió.
Of course,
Now-
Mr. Chairman, there
now
were
recognize
8
the
questions
gentleman.
before that he was not given a chance to answer.
No pudo responder porque no le dieron la
But the
oportunidad.
witness doesn't, Mr. Chairman, point of order. The witness does not control the
Punto de
time.
orden.
Exactly
El
right.
testigo no controla el tiempo.
Control the time.
Tiene razón, lo controlan los miembros. Si quieren cambiar de pregunta o pasar a otro tema, pueden hacerlo. Quiero darle la oportunidad al testigo de responder esa última pregunta. No la respondió, alguien más lo va a hacer. Tiene la palabra el caballero de Tennessee.
Follow up a few of the questions were asked here. Did Devon Archer
Volviendo a algunas preguntas, ¿Devon Archer no dijo que Joe Biden no hizo nada de malo?
Clear. I only know about Mr. Archer from newspaper reports.
Solo sé del señor Archer por lo que he visto en la prensa. Yo he cumplido mi promesa de no involucrarme en la investigación.
Biden did nothing wrong? Secondly,
Él dijo que Joe Biden no hizo nada de malo.
Trump,
Segundo,
President Trump appointed Weiss.
usted dijo que el presidente Trump nombró a Weiss y usted lo ratificó. Sí, el presidente Trump fue quien lo nombró. Y dice que el departamento está usado como un arma. ¿Qué pasó en la investigación del señor Gates? El Departamento de Justicia no comenta sus investigaciones. Eso fue un interesante intercambio. Usted es el principal funcionario policial del país. Una función clave del gobierno es combatir la criminalidad. Necesitamos autoridades efectivas. Quisiera concentrarme en algo que toca directamente al pueblo estadounidense, la criminalidad. ¿Cómo podemos tener una asignación más inteligente de recursos sobre estos programas? Hemos bajado los estándares para poder contratar gente. Esa no es la manera de hacerlo. Se pide una revisión de políticas y procedimientos. Gracias por hacerlo. ¿Qué puede hacer el Departamento de Justicia para que el departamento funcione de manera más eficiente? La clave de esto es nuestra alianza con el FBI, el Servicio de Alguaciles ATF, colaboración a todos los niveles, estatales y locales. En discusiones, todos los que procesan estos cargos criminales, incluyéndome yo mismo, sabemos que se necesita de la confianza de la comunidad. Nosotros en el Departamento de Justicia estamos ayudando a nuestros colegas a hacer precisamente esto. Lo que usted describe de estas oficinas, esto nos permite usar recursos para las organizaciones policiales que tienen problemas de reclutamiento, retención de personal, ascensos y demás. Y esto hace que sus departamentos puedan respetar los derechos constitucionales y puedan ser efectivos. Gracias por esas actividades y programas. Usted también reestableció programas con departamentos de policía, por ejemplo en Memphis. ¿Puede decirnos cuán importantes son estos programas? El Congreso ha autorizado al Departamento de Justicia a realizar investigaciones cuando se pueda considerar que hay un patrón de comportamiento inconstitucional del Departamento de Policía. Nosotros hacemos estas investigaciones y trabajamos con organismos policiales en las ciudades. Esperamos llegar a un acuerdo que nos permita tener un sistema mejor, constitucional, y queremos llegar a acuerdos sobre este tema. En cuanto a los cargos federales contra los 5 oficiales que mataron a Tyre Nichols, gracias por eso. Necesitamos esa gestión. Si hubiera un cierre del gobierno, ¿cómo afectaría eso al Departamento de Justicia?
I haven't done a complete calculation on the effects of a shutdown.
Yo no he calculado el efecto de un cierre del gobierno. Tenemos trabajadores esenciales. Esto afectaría a todos los programas normales, incluyendo nuestros programas de asistencia a los cuerpos policiales estatales y locales, nuestra capacidad de realizar operaciones rutinarias y el alcance entero de nuestras actividades. Gracias.
Thank you, Mr. Chairman. Mr. Attorney General, looking again at the appointment of Jack Smith and David Weiss, this double standard of justice.
Este doble estándar.
Jack Smith was deeply involved in the IRS scandal that targeted conservative political groups to harass. His malicious prosecution of former Governor McDonnell was unanimously overturned by the U.S. Supreme Court. Chief Justice Roberts rebuked Smith directly for attempting to criminalize political activity. You appointed him to prosecute.
Usted lo nombró para que se encargara de procesar al principal rival de Joe Biden para la presidencia. Weiss permitió que expiraran los lapsos en cualquier cargo que pudiera haber implicado a Joe Biden en tráfico de influencias. Él ofreció un acuerdo a Joe Biden y él es la persona que usted designó para cargos que pudieran implicar a Joe Biden. Así que la única implicación aquí es o corrupción o incompetencia. ¿Cuál es cuál? Estas son las preguntas que un juez consideraría que están fuera de lugar. Seguramente. El señor Weiss fue el fiscal nombrado por un republicano. Pero ¿usted ve el estándar obvio que hay aquí? En este caso, en estos dos nombramientos, el señor Weiss fue designado por un republicano. Él no está afiliado con ningún partido. No estoy hablando de su afiliación política, hablando de los antecedentes y cómo tiene que ver esto con sus nombramientos. Es una cuestión de criterio y motivos. ¿Por qué lo hizo? El señor Smith goza de reputación nacional, de integridad. Por favor, su trabajo se puede medir por lo que él ha hecho. Cualquiera en el país puede ver este encauzamiento. ¿Cómo puede decir eso después que estuvo tan implicado en el escándalo del servicio de rentas internas? O en muchos otros ejemplos. Permítame continuar. Ha habido denuncias de funcionarios sobre obstrucción de investigaciones, sobre millones de dólares mal habidos de Hunter Biden. Han hablado de cómo el departamento se ha desviado de las normas para darle tratamiento preferencial a Hunter Biden, incluyendo permitir la expiración de lapsos, investigaciones que se han demorado, entrevistas a testigos, impedir que haya entrevistas de los abogados de la defensa. E incluso se le dio información a los abogados de Biden de que iba a haber allanamientos donde él tenía sus documentos. Para mí eso suena a obstrucción de justicia. ¿Eso vino de usted o de alguien más? No entiendo la pregunta. Todas estas acciones de sus empleados para obstruir la investigación de Hunter Biden y sobre sus ingresos y sobre los impuestos que no pagó, ¿de dónde venía el dinero? Nuevamente, en cuanto a la investigación de Hunter Biden, esta está en manos del señor Weiss. alguien que fue nombrado por el presidente Trump. Yo no sé de estas alegaciones. Algunas parece que se remontan a la época en que el fiscal, el secretario de Justicia, había sido nombrado por el presidente Trump. ¿Le preocupa esto? El señor Weiss tendrá la oportunidad de explicar sus decisiones. Pero no le preocupa esto. Usted es el que está a cargo. Intencionalmente he decidido no involucrarme en este caso, no porque quiera evadir responsabilidades, sino porque quiero cumplir mi responsabilidad. El director del FBI le dijo a esta comisión de un repunte en casos de presuntos terroristas cruzando por la frontera sur y dijo que la frontera sur representaba una grave amenaza de seguridad. ¿Está de acuerdo? Con gusto me solidarizo con lo que dijo el director del FBI. ¿Por qué entonces se rescindieron las órdenes del gobierno de Trump de garantizar la seguridad en la frontera? Ha expirado su tiempo, puede responder el testigo. La respuesta a esta pregunta sobre ley de inmigración es muy larga. Lo remitiría al Departamento de Seguridad Nacional, responsable por la seguridad física en la frontera. Tratamos que él nos respondiera y no fue posible. El secretario pidió receso, regresamos en 5 minutos.
Thank you, Mr. Chairman. Attorney General Garland, great to see you. Thank you for your service to the nation. And the nation watches as the Republicans have no answer for why they want to focus and obsess on Hunter Biden receiving $2 million from Burisma after serving on a board that he said he was not qualified to serve on. But yet, the Saudi Arabians gave $2 billion to Jared Kushner, who conducted Middle East strategy for his dear old dad, Donald Trump. He got $2 billion for something that he is not equipped to do, which is investment banking. And so Republicans looking at Hunter Biden instead of Jared Kushner, Americans don't understand how that could be. And they also are increasingly alarmed about the fact that the Republicans in control of the House only seem to have three objectives. One is to impeach Joe Biden. Number two is to shut down, is to impeach or get rid of Kevin McCarthy, actually. And the third is to shut down government. And a subset of that is to defund the DOJ and the FBI for trying to hold Donald Trump accountable. So the American people are watching that, and they also appreciate the fact that you've had a distinguished career as a prosecutor and a DOJ official, as well as 24 years on the bench. You served on the second highest court of the land as a judge for 24 years, the D.C. Circuit Court of Appeals. We appreciate your service. You were, for 7 years, the lead, you managed that entire office. We thank you for that. You also served on the Judicial Council for a number of years. And so you are steeped in the rule of law. You are a judge extraordinaire. And as a judge, you never had the occasion to receive a private jet travel to an exotic location by a corporate billionaire, did you? You can cut your mic on.
No.
You never received an offer to get a ride on a private jet?
No.
Did you take any vacations at exclusive resorts paid for by a billionaire?
I know these are not hypothetical questions, and I think this is really
yes
not
no.
within my realm, of course.
I mean, you were a judge extraordinaire, and you know the rules of ethics for judges because your bench was covered by a code of conduct. Is that not correct?
Yes, all the judges, federal appellate and district judges, are covered by the code of conduct.
You would never have had somebody to pay for your godson's tuition to private school.
And I don't want to answer these kind of hypothetical, at least for me, they're hypothetical questions. What I would say is that I always, as a judge, and I've said this before and quite publicly and long ago, always held myself to the highest standards of ethical responsibility imposed by the code, and that's really all I can answer here.
And it's required that judges and justices avoid even appearances of impropriety. Isn't that correct?
Again, I know you're asking this both hypothetically and non-hypothetically. All I can say is I follow the code of judicial conduct, and it includes avoiding appearances. That's
well,
right.
Let me ask you this question. Senator Whitehouse and I sent a letter to you alerting you to the fact that we were asking the Judicial Council to refer the matter of Clarence Thomas being in violation of the Ethics in Government Act to the Justice Department. And after that, Representative Alexandria Ocasio-Cortez, along with myself and others, requested that you take that matter up directly Have you responded to either one of those letters, and if not, why not? And what action have you taken pursuant to those letters?
Gentleman may respond.
I assume that if you sent the letter, we have it, and I'll speak to the Office of Legislative Affairs about where it is at this point.
Is the
The time the
department investigating?
gentleman has expired. The chair now recognizes the gentleman from California, Mr. Issa.
Thank you. Good day, Mr. Attorney General. And this may be the reason that it's good for you to leave the Chief Justice and that group before each of us speak, because you would have already heard all that. I want to thank you personally for your office and your engagement on Camp Lejeune and on obviously a vast amount of litigation. That is one of the many, many jobs that falls at your feet. One of the jobs that falls at our feet here is that we are watchdogs of the executive branch. You have previously said that you are not Congress's attorney, and you've said you're not the president's attorney. And I'm assuming that you're neither our prosecutor nor our defense attorney, and you are neither the president's prosecutor nor defense attorney. And that's why today's investigation really does deal with the fact that if you're not, by definition, the president's prosecutor, but we have an obligation to see whether or not the president or a member of his family or in concert with the president's activities, in fact, need to be overseen, admonished, or even prosecuted. And so I have a couple of questions for you, and one of them is that you have not said this very much today, but you often say, I cannot comment on that because it's an ongoing investigation. And when we ask for information, you very commonly say that it is the policy, not the law, but the policy of the Department of Justice not to provide information related to an ongoing investigation. So far, I'm on track. Is that correct?
I think I've said more than it's just a policy. I think the letters we've sent trace it to the constitutional separation of powers, to Rule 6E of the Federal Rules of Criminal Procedure, et cetera. But in general, I'm in accord with what you're saying.
So one of the challenges we face is that just a matter of weeks ago, a federal judge found the actions of now special prosecutor to be so outside what he could agree to that he pushed back on a plea settlement and nullified it and sent the U.S. attorney going back. In light of that, don't you think it's appropriate for that portion to be considered a pre-ongoing investigation and for Congress to legitimately look at the activities leading up to that failed plea bargain rather than wait until weeks, months, or years from now a case is fully settled?
Yeah. So if you'll give me a chance, first, I don't agree with the characterization of what happened in the plea. The district judge performed her obligations under Rule 11 to determine whether the parties were in agreement as to what each had agreed to and determined that they were not. Plea fell apart, as you know. There's been another prosecution. So that leads to the second thing. We are in, Mr. Weiss is in the midst of an ongoing prosecution on the very matter that you're talking about.
Okay, but Mr. Attorney General, if we believe, and we do, at least on this side of the dais, that a pattern of behavior is occurring relative to the investigation of Hunter Biden, particularly and including, well, he lived in the vice president's home, well, he operated commingled with the vice president, and even today as he travels with the president. So in light of that, can you agree that, in fact, it should be reasonable for us to look at a number of items, including, and one that I want your answer on, and I know we have limited time, Mr. Weiss supposedly had this ability to bring a prosecution anywhere. He now explicitly has that ability. However, are you concerned, and should we have the right to look into the fact that political appointees in California and in the District of Columbia refused to, in fact, cooperate with him in those investigation that he was charged with doing in Delaware, but which flowed over into their jurisdictions? Isn't that, in fact, an example where those political appointees of the now president, that their decision not to cooperate with him creates at least an appearance of political interference with the investigation of the president's son and possibly activities related to the president?
Look, I'm happy to answer this question in hypothetical, but not in the specifics, because I have stayed out of this matter. In the hypothetical, it is the normal process of the department that if a U.S. attorney in one district wants to bring a case in another, they go to that other district and consult. It's perfectly appropriate. They do that in order to determine what the policies are in that district, what the practices have been in that district, what the judges are like in that district. A U.S. attorney in another district does not have the authority to deny another U.S. attorney the ability to go forward, and I have assured Mr. Weiss that he would have the authority one way or the other, and I think Mr. Weiss's letters completely reflect that.
Thank you. To be continued.
Time the gentleman has expired. The chair recognizes the gentleman from California for 5 minutes.
Welcome, Mr. Attorney General, and thank you for leading the department with such integrity. We meet today at a momentous time in our history. The country is about to go through a great trial. By this, I do not mean any of the several trials of the former president, but rather a trial of the proposition that we are a nation of laws, committed to the rule of law, and that no one is above the law. It is a proposition well known around the world because it is the one essential ingredient in all democracies. We have all professed our belief in this principle, but it has never been truly tested, not like it is today. In this committee, we are engaged in a portion of that trial. The chairman would abuse the power of this committee by trying to interfere in the prosecutions of Donald Trump, by trying to use the committee's power of subpoena to compel criminal discovery, in effect, making the committee a kind of criminal defense firm for the former president. In doing so, the chairman of this committee would establish a very different proposition. Through Mr. Jordan's actions, he would establish the principle that the rule of law should apply to almost everyone, just not the leader of his party. According to this alternate proposition, if you are the President of the United States and you lose your re-election, you can violate the law and Constitution to try to stay in power, and if you are successful, well then maybe you get to be president for life. And if you fail, there is no repercussion. This proposition is also well known to the world, and it is called dictatorship. Mr. Jordan hopes to camouflage his assault on the rule of law by falsely claiming that Donald Trump is the victim of unequal justice and Hunter Biden its beneficiary. It is a claim as transparently political as it is devoid of any factual basis. And it is cynical, based on the belief that the American people cannot discern fact from fiction. But I am betting on America. History has shown that those who bet against her are rarely successful, and more often they end up covered with shame. I believe in the rule of law, and I thank you, Mr. Attorney General, for defending it. Let me now turn to some of the false claims asserted by the former president and some on this committee. On Sunday, the former president appeared on a national news Sunday program and was asked about 4 indictments and 91 counts facing him. His response was, Biden indictments. Excuse me, Biden political indictments. He said to the Attorney General, indict him. Mr. Attorney General, I want to give you a chance to respond. Was the president telling the truth, or was he lying when he said that President Biden told you to indict him?
No one has told me to indict, and in this case, the decision to indict was made by the special counsel.
So that statement the president made on Sunday was false?
I'm just going to say again that no one has told me who should be indicted in any matter like this, and the decision about indictment was made by Mr. Smith.
Let me ask you this question about the prosecution of Hunter Biden. The prosecutor in that case, Mr. Weiss, was appointed not by Joe Biden, but he was appointed in the first instance by Donald Trump. Is that correct?
That's correct.
And he was continued in that position, was he not?
He was continued in that position, yes.
And Mr. Attorney General, can you imagine the hue and cry you would hear from my colleagues on the other side of the aisle if you had removed him from that position? Can you imagine the claims that you had removed a prosecutor who was diligently investigating Hunter Biden? Can you imagine the outrage they would have expressed?
I can say that during my confirmation hearing, I discussed with many senators on that side of the aisle their desire and actual insistence that Mr. Weiss be continued to have responsibility for that matter. And I promised, and I said at my confirmation hearing, that he would be permitted to stay and that I would not interfere.
And Mr. Attorney General, that was exactly the right decision. That was the right decision to give the American people the confidence that even a prosecutor chosen by the former president would continue in the investigation into the son of the current president. That was exactly the right decision. Exactly the right decision, and my colleagues on the other side of the aisle would have been screaming if it were otherwise. But their attack on you is completely devoid of fact, of principle, but I appreciate you doing the right thing for the Department of Justice and, more importantly, the right thing for the American people. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Kentucky.
Attorney General Garland, Elon Musk was a Democrat who admittedly supported Biden, but then he became a critic of the administration and exposed the censorship regime. Now, per public reports, the DOJ has opened not one but two investigations of Elon Musk. Mark Zuckerberg, on the other hand, spent $400 million in 2020 tilting the elections secretly for Democrats. No investigations whatsoever. To the American public, these look like mafia tactics. You pays your money, we look the other way. You get in our way, we punish you. The American public sees what these tactics are. Now I want to direct your attention to a video here that we're going to play.
Obviously, that's a significant matter. It is an ongoing criminal investigation, and so I'm not going to comment on an ongoing criminal investigation.
Were those pipe bombs operable?
Again,
the ATF is the expert.
Again, it's an ongoing criminal investigation, and under long-standing policy, I cannot comment.
As you know, this is a very active, ongoing investigation, and there are some restrictions on that, but we will do
we
our
can
best
handle
to
classified information, and we fund your department, and so you need to provide that.
It's not, respectfully, it's not an issue of classification. It's an issue of commenting on ongoing criminal investigations, which is something that by long-standing department policy we are restricted in doing. And in fact, the last administration actually strengthened those policies partly
That's
because—
not our policy, though, and we fund you, so let's move on. Do you know how—
So I'm not going to violate this norm of the rule of law. I'm not going to comment on an investigation that's ongoing.
Peter Navarro was indicted for contempt of Congress. Aren't you, in fact, in contempt of Congress when you give us this answer? This is an answer that's appropriate at a press conference. It's not an answer that's appropriate when we are asking questions. We are the committee that is responsible for your creation, for your existence of your department. You cannot continue to give us these answers. Aren't you, in fact, in contempt of Congress when you refuse to answer?
Congressman, I have the greatest respect for Congress. I also have the greatest respect for the Constitution and laws of the United States. The protection of pending investigations and ongoing investigations, as I briefly discussed in another dialogue a few moments ago, goes back to the separation of powers, which gives to the executive branch the sole authority to conduct prosecutions. It's a requirement of due process and respect for those who are under investigation, the protection of their civil rights.
Well, with all due respect to that, Iran-Contra was an ongoing investigation, and that didn't stop Congress from getting the answers. And you're getting in the way of our constitutional duty. You're citing the Constitution. I'm going to cite it. It's our constitutional duty to do oversight. Now, in that video, that was your answer to a question to me 2 years ago when I said how many agents or assets of the government were present on January 5th and January 6th and agitating in the crowd to go into the Capitol and how many went into the Capitol. Can you answer that now?
I don't know the answer to that question.
Oh, last time, you don't know how many there were or there were none?
I don't know the answer to either of those questions. If there were any, I don't know how many. I don't know whether there are any.
I think you may have just perjured yourself that you don't know that there were any. You want to say that again, that you don't know that there were any?
I have no personal knowledge of this matter. I think what I said the last time.
You've had 2 years to find out. And the day, by the way, that was in reference to Ray Epps, and yesterday you indicted him. Isn't that a wonderful coincidence? On a misdemeanor. Meanwhile, you're sending grandmas to prison. You're putting people away for 20 years for merely filming. Some people weren't even there yet. You got the guy on video who's saying go into the Capitol. He's directing people to the Capitol before the speech ends. He's at the site of the first breach. You've got all the goods on him, 10 videos, and it's an indictment for a misdemeanor? The American public isn't buying it. I yield the balance of my time to Chairman Jordan.
May I answer the question?
I'm going to ask you one now. Yeah, we'll let the gentleman.
Yeah.
Go ahead, but
in discovery, in the cases that were filed with respect to January 6, the Justice Department prosecutors provided whatever information they had about the question that you're asking. With respect to Mr. Epps, the FBI has said that he was not an employee or informant of the FBI. Mr. Epps has been charged, and there's a proceeding, I believe, going on today on that subject.
the charge is a joke. I yield to the Chairman.
The time the gentleman has expired. The chair recognizes the gentleman from California.
Mr. Attorney General, my colleague just said that you should be held in contempt of Congress, and that is quite rich, because the guy who's leaving the hearing room right now, Mr. Jordan, is about 500 days into evading his subpoena, about 500 days. So if we're going to talk about contempt of Congress, let's get real. I mean, are you serious that Jim Jordan, a witness to one of the greatest crimes ever committed in America, a crime where more prosecutions have occurred than any crime committed in America, refuses to help his country, and we're going to get lectured about subpoena compliance and contempt of Congress? Jim Jordan won't even honor a lawful subpoena? Are you kidding me? Are you kidding me? There's no credibility on that side. Mr. Attorney General, you are serious, they are not. You are decent, they are not. You are fair, they are not. So I welcome you to the law firm of Insurrection LLP, where they work every single day on behalf of one client, Donald Trump. And they do that at the expense of millions of Americans who need the government to stay open, who want their kids safe in their schools, and would like to see Ukraine stay in the fight so that we don't help Russia. That's the expense that this nonsense, this clown show, I'd call it a clown show, except they actually have real responsibilities that affect real Americans. It's the difference between one side that believes in governing and one side that believes in ruling. You've tried to comply with this committee. In fact, last week, one of your special agents came here for an interview, brought his lawyer, and was told that he couldn't have his lawyer present. Mr. Jordan, who tells all of us he knows so much about the Constitution, wouldn't afford one of your employees one of the basic constitutional rights to have a lawyer present. In fact, they threatened to call the Capitol Police and arrest a lawyer that was brought. Are you familiar with that standoff that occurred last week, Mr. Attorney General?
Generally, yes.
Well, your office also sent a letter detailing it, that you were willing to comply, but you'd like him to have a lawyer, and I'd like to submit that to the record with unanimous consent.
Without objection.
Who appointed Mr. Weiss?
Mr. Trump was the last person who appointed Mr. Weiss to the position of U.S. Attorney. I appointed him to the position of Special Counsel last month.
Who initially appointed John Durham?
Mr. Durham was, I believe, also appointed by President Trump, and Mr. Barr appointed him as Special Counsel.
And again, these guys are so upset that Donald Trump's appointed prosecutors aren't doing enough of the corruption that Donald Trump wants them to do. So either they are just following the law, or they're not as corrupt, and they're not willing to go as far as they think that Donald Trump deserves. That's what they're asking to happen here. Also, doesn't it seem that they want it both ways when it comes to the special counsel? A lot of questions suggested that the special counsel should be independent, but when they didn't like the direction of the special counsel, you were asked why you didn't interfere more or involve yourself more or investigate more. Did you get that sense that you're kind of stuck here?
When I make an appointment, somebody be special counsel or prosecutor, the appointment is without respect to what the outcomes of the case will be.
Your office has made a number of reforms to 702, targeting foreign nationals, but those reforms have not been put into law. 702 is also one of the best weapons we have to go after fentanyl. Can you tell us if you would support putting some of those reforms into law so we don't have to live administration to administration to see if they're going to be followed?
I would. Section 702 provides us with the greatest amount, at least the Justice Department, every morning, the greatest amount of intelligence that we receive about dangerous threats to the United States.
From foreign nationals? From
foreign nationals. I am quite aware and sensitive to civil liberties concerns with respect to the queries. And for that reason, I put into place and I extended some of those that Mr. Barr had begun at the end of his term, and I put further ones in place. Those have led to a dramatic reduction in the number of queries and a dramatic reduction in the number of non-compliant queries. I believe those are appropriate reforms, and I would be in favor of codifying them, yes.
Thank you, Mr. Attorney General, and thank you for coming and doing something that the chairman is unwilling to do, testify to Congress. Yield back.
Gentleman yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald.
Attorney General, on August 11, 2023, you appointed Mr. David Weiss, U.S. Attorney for the District of Delaware, as special counsel to oversee the investigation of Hunter Biden. I don't think the question has been asked yet. Why did you choose to appoint him as special counsel?
The explanation was given, and as far and to the extent I can give I'm permitted to give an explanation, is the one I gave and sent to the Congress, which is that Mr. Weiss requested it, that I had promised to give him all the resources that he need, that he had reached the stage of the investigation where he thought it would be appropriate. And under those extraordinary circumstances, I thought the public interest would be served by making him special counsel.
How did Mr. Weiss's name emerge? Who recommended him? How was it brought to you or presented to you that this would be the best person to be the special counsel?
No, I'm not going to get into internal discussions. Mr. Weiss asked that he be appointed as special counsel, and I granted that request and made him special counsel, but I'm not going to get into internal deliberations in the Justice Department.
But I think you said earlier you've had no discussions with the White House and certainly the President in regards to that. Is that accurate?
Of course.
There were no suggestions that came from any other level of government on Mr.
Nothing came from the White House, that's right.
So on August 20th, 2023, the Washington Post article claimed that Mr. Weiss worked with Hunter Biden and Hunter Biden's late brother, Beau Biden. Were you aware that there was a relationship there with the Biden family?
I'm not familiar with this. I don't know when he did what.
They worked together on legal cases in prior years. You were unaware of this?
I'm not familiar with that.
And the article claims it would have been inevitable for Mr. Weiss and the president to cross paths in a state like Delaware. They knew each other. There was a relationship there, but you were unaware of any of this before you appointed him?
I'm unaware of this, but attorneys who are in practice certainly get to know people. So it's very difficult anywhere in the country for attorneys not to get to know attorneys on other sides of matters.
You said previously that Mr. Weiss had the ultimate authority over the investigation of the president's son, including prior to his appointment as special counsel. And you stand by that statement, I'm sure?
I'm sorry, I didn't.
Just that in fact, there was that the ultimate authority was still there with Mr. Weiss to make determinations on that case.
You mean still as special counsel? Yes.
Yes, as special counsel. So the buck stopped there, and that's been determined. According to whistleblower testimony, Mr. Weiss' deputy, AUSA Leslie Wolf, objected to search warrants of President Biden's guest house, denied investigation access to a storage unit containing all the documents from the vacated office of law firm. Is Leslie Wolf still employed by the Department of Justice?
I'm not going to talk about any individuals in the Justice Department. As I said before, singling out individuals has led to serious threats to their safety. I will say that the supervisor of this investigation was Mr. Weiss. He's responsible for all the decisions that were made. Excuse me. Many of the things that you're saying occurred during the previous administration. I apologize.
Okay. Well, there was absolutely a discussion by Leslie Wolf that if they told investigators or got involved with this, that there would ultimately be issues. You still believe that at this point that the entire investigation has moved in the correct discretion, was handled by the correct discretion of the individuals involved?
Mr. Weiss was a long-standing career prosecutor who was appointed by President Trump. He has an outstanding reputation, and I have confidence that he will proceed as appropriate. And at the end of his investigation, he will submit a public report, just like Mr. Durham, just like Mr. Mueller. He will be available for you to ask him questions about why he did various things that were done.
I yield the balance of my time to the chairman.
Mr. Garland, what changed? On July 10th, 2023, David Weiss wrote Senator Graham and said, I have not requested special counsel designation. August 11th, you announced that he's now the special counsel. What happened in that 31 days?
As I said publicly, several days before my announcement, I think 3 days, Mr. Weiss had asked to become special counsel. He explained that he had reached the stage of his investigation where he thought that appropriate.
What stage is that?
I had promised to give him the resources he needed.
What stage is that? He'd reached the stage. After 5 years, what stage are we in? We in the beginning stage, the middle stage, the end stage, the keep hiding the ball stage? What stage are we in?
I think this one I would go back to the videotape where I said I'm not permitted to discuss ongoing investigations.
Well, isn't that convenient? Something changed in 31 to 32 days from July 10th to August 11th. I think it's two brave whistleblowers came forward and a judge called BS on the plea deal. You guys tried to get past them. That's what I think happened. The chair now recognizes the gentleman from California.
Thank you, Mr. Chair. The House Judiciary Committee has the responsibility of helping to ensure the rule of law. Unfortunately, this committee's chairman ignored a bipartisan congressional subpoena. The horrible precedent set by this chairman has damaged the credibility of all congressional committees in seeking information from witnesses and damaged the rule of law. Attorney General Garland, thank you for your public service, and thank you for being here today. I'd like to start by showing a video of January 6th, and then I'm going to ask you some questions about that day.
Hey, brother, we're boots on the ground here. We're moving on to Capitol now. I'll give you a boots on the ground update here in a few.
Multiple capital entries! Multiple capital entries! We're still taking metal, sharpened objects, missiles to include bottles and rocks, and hand-thrown chemical-grade fireworks. This is now effectively a riot.
1349 hours declaring it a riot.
Attorney General Garland, the Department of Justice charged over 1,100 defendants in connection with the attack on our Capitol, correct?
Yes, that's correct.
I'm going to state two facts. The people who showed up on January 6th to attack the nation's Capitol were supporters of Donald Trump. They attacked the Capitol to stop Congress from certifying the fact that Donald Trump lost the election. Those two facts were so horrible that some in the right-wing media and some Republican members of Congress could not handle that, so they made up conspiracy theories. In fact, Donald Trump called January 6th a beautiful day. He said the people who showed up had love in their hearts. The Republican member of Congress said January 6th was like a normal tourist visit, and some Republicans have said there were no weapons used on January 6th. Attorney General Garland, were there weapons used in the attack on January 6th?
Yes, in the video you already saw some of the weapons that were used, and there are obviously many more, many hours of video.
Another conspiracy theory is that somehow the FBI actually orchestrated this attack. So I'm going to go through some cases that have gone through completion and resulted in sentencing. Joe Biggs was sentenced to 17 years in prison for seditious conspiracy and other counts related to attack on our nation's capital. Have you seen any shred of evidence that Joe Biggs was an FBI agent?
No.
In fact, Joe Biggs was a member of the Proud Boys. This is what Assistant U.S. Attorney Connor Monroe stated about Joe Biggs and the Proud Boys in court. He stated, quote, "They saw themselves as Donald Trump's army, fighting to keep their preferred leader in power no matter what the law or the courts had to say about it." And on September 4th, Joe Biggs stated that he is confident Trump will pardon him. He said, quote, "Oh, I know he'll pardon us. We're his supporters. We went there like he asked." I'd like to now ask you about the case of Stuart Rhodes, who was sentenced to 18 years in prison for the attack on our nation's capital. Have you seen any shred of evidence that Stuart Rhodes was an FBI agent?
No.
In fact, he was the founder of the Oath Keepers, a far-right paramilitary organization. Rhodes asked Donald Trump to call them up as militia. And I'd like to ask you about Enrique Tarrio, who was sentenced to 22 years in the attack on our nation's capital. Have you seen any evidence that Enrique Tarrio was an FBI agent?
He was not an FBI agent.
In fact, he was the leader of the Proud Boys. What happened on January 6th is that Donald Trump's supporters showed up because he told them to. They marched to the Capitol because he told them to. They attacked the Capitol because he told them to stop the steal. That is the truth, and that is how history is going to record it. Thank you for prosecuting those who attacked our nation's capital. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from South Carolina.
Thank you, Mr. Chairman. I have a slide up here, and I'll start. In October or March of 22, Mr. Weiss was denied the ability to bring charges against Hunter Biden in the District of Columbia. In April of that same year, you testified before the Senate Appropriations Committee that Mr. Weiss was free to run the investigation without interference from the DOJ. According to the IRS whistleblower, there was a meeting in October of 22 where Mr. Weiss said that he was not the deciding official on whether charges were filed. And we know that because we have handwritten notes from the IRS whistleblowers that was confirmed in an email to people in the meeting. Later in January, Mr. Weiss was denied the ability to bring charges again against Hunter Biden in the Central District of California. You testified before the Senate Judiciary Committee in March of this year that he had full authority. That Weiss confirmed that to us in a letter in June, that he had been granted, quote, full authority over this matter. But then he kind of backed up. In June 30th, he said, well, just kidding. My charging authority is geographically limited to my home district in Delaware. And of course, you appoint him as special counsel. So why the heck has his story changed so many times over the course of these investigations?
Congressman, I've seen all of the 3 letters. I've read them quite carefully. They are all consistent with each other, and I urge everyone watching this on television or anyone who's interested to look at those 3 letters. They are not inconsistent with each other, and there's no change in the story.
So, but you agree that he had, and you've said this publicly, that he had ultimate authority prior to the appointment of special counsel?
I've explained this repeatedly here. I've explained this in another proceeding. I said that Mr. Weiss would have the authority to bring a case in any jurisdiction in which he wanted to, and Mr. Weiss has confirmed that he would have that authority. I explained that if he had to bring a case in another jurisdiction, as a matter of mechanics, it would require me me or a delegatee of mine to sign a 515 order. That is very common.
But Mr. Attorney General,
there was nothing stopping that from happening.
Forgive me for a second, though, but when you say you have ultimate, when he wrote a letter on your behalf in June, I have ultimate authority. This is prior to the designation of special counsel. Ultimate to me means like that you can go wherever you want to.
Ultimate means when
at that particular point, sir, could he file charges in the District of South Carolina? He would not have that ability, correct? He would have to go through that U.S. attorney. So that's not full authority.
All he would have to do is ask me for 515 authority, and I would sign it right away, just like when he asked me to be special counsel. Within 3 days, I signed that.
So he didn't have ultimate authority.
He had the authority because I promised that he would have the authority.
But he did not have that authority. See, here's where I'm going. If he was denied the ability to bring charges in March of 22 in the District of Columbia, if he was denied the ability to bring charges in January of 23 in the Central District of California, that's not full authority. These U.S. attorneys operate as gatekeepers, so that's not full authority to do much of anything. And you know what's remarkable to me? We sit here and we look at this, and his story has changed so many times. You know whose story hasn't changed? Mr. Shapley, Mr. Ziegler, the emails that confirm that he said, I'm not the deciding person on whether charges are filed. And you know what the response back was from his colleague at work? Yep, you covered it all, Gary. That is consistent. What Mr. Weiss has done is this shell game and saying that he has authority, he doesn't have authority, but these gatekeepers at the U.S. Attorney's Office in the District of Columbia and in the Central District of California, they would have the gatekeeping authority on whether charges are brought in their jurisdictions.
I'm sorry,
absent that designation, correct?
Those words have no meaning, gatekeepers, et cetera. Mr. Weiss said he was never denied authority. I'm the one with the authority to decide who can prosecute in a different jurisdiction, and I promised that he would have that authority. I do not see any inconsistency here. I was not at the meeting that Mr. Shapley was referring to. I know what I guaranteed, and I know what Mr. Weiss has said I guaranteed.
Mr. Chairman, I yield the balance of my time.
It's a simple question. If he already had it, why does he need it? That's the question. You said in your statement on August 11th, you said he will continue to have the authority to bring charges where, when, and wherever he decides. So how can he continue to have a power that you just gave him? That's the fundamental question the gentleman from South Carolina was asking. If he already had it, why does he need it?
And I tried to answer that he had the authority, and he continued to have
When
the
did he
authority.
specifically ask you, did you tell him ahead of time that he could get 515 status anytime? When did you tell him that he could get that if he requested it?
I made absolutely clear.
When? Did you tell him at the start of the
I made
investigation?
clear from the beginning in my statements to the Senate that he would have the authority to make any decisions that he wanted to and bring prosecutions he thought were appropriate.
The time the gentleman from South Carolina has expired. The gentlelady from Washington is recognized for 5 minutes.
Thank you, Mr. Chairman. Attorney General Garland, thank you for your tremendous service to this country. As somebody who was trapped in the gallery on January 6th, I have to admit it's still hard for me to look at that video and imagine that that happened at our U.S. Capitol. And I'm deeply grateful that you have led this nation towards accountability of all those who were involved, including the former president. You have done so with full and complete attention to the facts, with a team around you that focuses on thorough investigation, and with a very clear mission that you've stated over and over and over again, despite the asked and answered on the other side, that the Justice Department works for the American people. This is a night and day transformation from a Justice Department that was constantly used by Donald Trump for his own political gain. And it is my firm belief that we have to hold those accountable who tried to destroy our country, including the former president, or we risk losing our country altogether. So I thank you for your steadfast leadership. It is just sad that this committee has also been transformed into a soapbox for political conspiracy theorists, instead of focusing on the really important issues that the American people care about. And so that's what I'm going to try to do. I'm going to focus on the critical crisis of reproductive freedom and the efforts to try and strip reproductive freedom from people across this country. As you know, a decades-long project of the extreme right wing materialized last year when 5 Republican-appointed justices overturned 50 years of precedent that established the constitutional right to abortion. As one of the 1 in 4 women across this country who has had an abortion and who felt compelled to share my story after decades because I saw the attacks on the right to abortion and what it would do particularly for poor women, for Black and brown and indigenous people across this country, I spoke out and shared that story. In the 22 states where Republicans control the state legislature and governorship today, all have moved to restrict reproductive rights. More than 25 million women of childbearing age now live in states where abortion access has been curtailed. And in Washington state, my home state, the Seattle Times reported that we are seeing increasing numbers of abortion patients, not only from neighboring Idaho, which we knew we would see, but also from other southern states where these restrictions are enforced. Mr. Chairman, I seek unanimous consent to enter this Seattle Times article into the record. She traveled 2,000 miles secretly for her Washington abortion. Why patients from the South are coming here.
Without objection.
As our fundamental freedoms are threatened by extreme MAGA Republicans in Congress and across the country, we trust that the DOJ will initiate investigations and file lawsuits to protect reproductive rights. With respect to mifepristone, what has the department done to protect access to this very safe abortion drug that women can take at home safely and to end a pregnancy?
So the FDA authorized the use of mifepristone as safe and effective, and it did it back in 2000. That's been challenged, first in the district court when we defended the FDA in that matter. There was an appeal in to the circuit court, which narrowed the district court's opinion in some ways, but allowed it to go forward in other. We have filed a cert petition, which has been granted, I think, in the Supreme Court of the United States.
Very, very important work. Thank you. My home state of Washington has one of the highest rates of religiously affiliated hospitals in the country, with our state's insurance commissioner's office reporting that in 2021, there were several counties lacking even one secular hospital. This is an issue under the Emergency Medical Treatment and Labor Act when patients in need of abortion care as a life-saving treatment are denied services under the hospital's policies. What is the department doing to enforce this law mandating that every hospital that receives Medicare funds provide, quote, necessary stabilizing treatment to patients, including abortion care?
You're right. This is a federal law. It expressly preempts any inconsistent state law. For that reason, we filed a lawsuit in Idaho and one in the district court with respect to an Idaho law that impinged on the rights granted under EMTALA. We have filed, I think, a number of statements of interest in other places, and we're continuing to look at where it would be appropriate to intervene.
Thank you. You're on record stating that women who reside in states that have banned access to comprehensive reproductive care must remain free to seek that care in states where it is legal. I thank you for that. Can you briefly discuss the progress made by the task force and DOJ to ensure that pregnant people retain their right to travel?
Yes, look, my view about this right to travel is the same as Justice Kavanaugh's in his separate opinion. He said, this is not a particularly difficult question. The right to travel is a constitutional right, and it allows a woman in a state that bars abortion to travel and obtain an abortion in a state in which it's permitted.
Thank you, Attorney General, for your commitment to this issue and to upholding the rule of law in our country. Appreciate your service.
Time of the delay has expired. The gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Attorney General, for being here today. I would like to go back briefly to your remarks regarding before the Senate when you were confirmed and your promise regarding Mr. Weiss. Can you explain to us in a little more detail who you promised that you would keep Mr. Weiss on this case? To whom was that promise made?
Yeah, so a number of senators in my meetings with them asked me to make that promise. I think that was discussed in my interchange with a senator from Tennessee, I believe.
And did that promise that you made lead you to believe that even if that Mr. Weiss displayed a level of incompetence, that you would be precluded from asking him to step down or precluded from replacing him?
Look, when someone asks me to make this appointment, they didn't ask me depending upon what the outcome was. Mr. Weiss has made his appointment, decisions, and Mr. Weiss is an experienced federal prosecutor with extensive experience and with sufficient credibility to be appointed by President Trump. I just have no grounds for interfering here.
Right, so you haven't answered the question. The question was really what level of incompetence displayed by a prosecutor under your control would it take for you to make a change? But let's move on. The level of incompetence I'm referring to, I'll just read this to you. This is the same Weiss who headed an investigation that was trashed by whistleblowers who alleged that his investigation had been fixed from the outset. It's the same Weiss who ran an investigation in which agents were allegedly prevented from asking about Joe Biden, obstructed in their efforts to pursue questions, compromised by tip-offs to the Biden team on planned searches. It was the same Weiss who reportedly allowed the statute of limitations to run out on Hunter's major tax offenses, even though he had the option to extend it. It was the same Weiss who did not indict on major tax felonies and cut a plea deal that brushed aside a felony gun charge. It was the same Weiss who inked a widely panned sweetheart deal that caused a federal judge to balk it and trash a sweeping immunity grant, language that even the prosecutor admitted never been seen in a previous plea deal. So there's a list of what I would suggest under many people's definition would be incompetence. Are you saying that that's inadequate for you to have questioned what he was doing?
I'm saying that all of these are allegations. I don't know what the facts of them are. I have, as I've explained, stayed out of this investigation. I was not present at any of the meetings discussed. Some of the meetings occurred under the previous administration, where Mr. Weiss was assigned to the matter by the previous Justice Department, and I'm not in a position to comment on them.
That's too bad. Is that there's a scope of investigation memo generally issued when we start these things out. Who issued that scope of investigation memo to Mr. Weiss? Was it done back on when he was originally appointed to take on the Biden case? Is that when the memo was telling him what he was supposed to do was issued? Is there a scope of investigation memo is my question.
There's a scope of investigation with respect to special counsel, and that has been publicly transmitted to the chairman of this Judiciary Committee and the Senate Judiciary Committee.
And who wrote it?
Who wrote that scope?
Yeah. Who decided what should be within the scope of that investigation?
I'm sorry?
Who wrote the memo? Who decided what the scope of that?
I decided what should be in the scope. If you'll compare that to the scope of many other special counsels, it basically is modeled on the format that we've used in the past, not only in this administration, but the previous one.
In your remarks delivered on August 11th of this year concerning the appointment of David Weiss as special counsel, you say, upon considering his request, as well as, quote, the extraordinary circumstances relating to this matter, end quote. Can you tell us what those extraordinary circumstances were?
I'm sorry.
Okay, so these are your remarks back on August 11th.
Yes.
And it says, on Tuesday of this week, Mr. Weiss advised me that, I'm just quoting from your memo, this is what he said.
Yes.
In his judgment, his investigation has reached a stage at which he should continue his work as special counsel, and he asked to be so appointed. Upon considering his request, as well as, quote, the extraordinary circumstances related to this matter, end quote, I've concluded it's in the best public interest to appoint him special counsel. What were those extraordinary circumstances you're talking about?
Yeah, look, all of these special counsels, including the appointment by Mr. Barr with respect to Mr. Durham, uses those phrases. The reason he uses those phrases is because that's in the special counsel regulation. I've said as much as I can say with respect to that without discussing matters relating to a pending investigation. I can't discuss matters with respect to a pending investigation for the reasons I've said.
Thank you.
Gentleman yields back. The gentleman from California is recognized.
Thank you, Mr. Chairman. Mr. Garland, I want to welcome you today to this hearing. Want to turn our attention to something very interesting, more important. The most important thing on Main Street today in my district is drug addiction, narcotics, trafficking, fentanyl. I'm going to quote you June 23rd of this year. You said, I open quote. The U.S. government continues to do everything in our power to disrupt fentanyl trafficking and to prevent more of our communities from being devastated by the fentanyl epidemic. We went on to say we are targeting every step of the movement, manufacturing, and the sale of fentanyl from start to finish. Mr. Garland, I believe that the only thing that cartel leaders fear is a United States prison. I want to thank you for the good job. You recently extradited Oviedo Guzman Lopez, El Chapo's son. Thank you very much for that good job. My question is, do you have plans to extradite additional cartel leaders from other parts of the world to the United States to face U.S. justice and a U.S. prison sentence?
Yeah, I don't want to get into discussions, diplomatic discussions over the matter, but obviously we have indicted the other Chapitos, Chapito being the nickname given to the sons of El Chapo.
How many of those? How many are there of those?
Trying to remember, I think there are maybe 4 more, maybe 5, I'm not sure exactly. But they've all been publicly indicted, and of course we will seek the extradition of it and the apprehension of everyone we've indicted.
The apprehension, the indictment of these individuals requires that you have cooperation from foreign countries, especially Mexico, since that's where a lot of these cartels are operating. Would you say right now Mexico is cooperating with us in terms of working with your office to bring these cartel leaders to justice?
They've obviously worked with us with respect to Ovidio. His apprehension by the Mexicans led to the deaths of a significant number of Mexican Marines. Ovidio's people fighting back with 50 caliber machine guns, and the Marines having to use Black Hawk attack helicopters in order to arrest him.
Are these U.S. Marines or Mexican?
I'm sorry?
Marines? United States Marines?
No, I'm sorry, Mexican Marines. It's the Mexican Marines who are playing an important role in the apprehension of the cartel leaders.
So, Mr. Garland, would you characterize cooperation right now with Mexicans as being good, not good?
I would say cooperation can always be better. We have an enormous problem with respect to fentanyl coming from Mexico, from its manufacture there, based on the precursors coming from China, based on the cartel leaders.
How can we as members of Congress help you make sure that other countries have stronger cooperating relationship with us? How can we make sure that they cooperate to their fullest abilities with you?
I appreciate that request. I'll have to think about it some more. I will say that I've personally traveled to Mexico twice to try to get cooperation with respect to these matters.
How important is FISA and 702 to your job when it comes to fighting narco fentanyl?
It's very important. Fentanyl poses a national security problem for the United States.
So can you work with us to assure that we put guardrails put guardrails, safety measures on 702 to assure that those investigative weapons are not turned against U.S. citizens?
Absolutely. 702 is a crucial, essential tool, but like all tools, it has to be properly controlled. And we would be happy to work with Congress to make sure the civil liberties are protected.
My last minute, I wanted to turn to the antitrust area, the European Union, and the Digital Marketing Act, which is Digital Markets Act, which is designed to protect consumers in Europe. Yet, it looks like most of their focus is on American firms. No European companies or other foreign operators in the European Union are being targeted. It looks like it's only American firms operating in Europe. And it looks like the DOJ is working to support the efforts of the Europeans in implementing the Digital Marketing Act. I have 18 seconds. I'm going to submit a written question to your office. But my focus, my interest is making sure American jobs, American companies are successful around the globe and that they are not in any way hampered from working overseas. Thank you very much, Mr. Chairman. I ran out of time.
Gentleman yields back. The gentleman from New Jersey is recognized for 5 minutes. Jeff.
Thank you, Mr. Chairman. Welcome, Attorney General. You know, following your confirmation, Americans were promised they were getting a focused, nonpartisan, to lead their federal law enforcement. I had my doubts back then. And the last 2 years have more than confirmed in my mind those fears. Never in my life would I have thought that I would see such a politicized DOJ. Never in my life would I have thought I would see such a Department of Justice that didn't obey their own rules. Never in my life did I think I would see the egregious investigations conducted under your watch, or the blatant disregard of the First Amendment by FBI field offices under your watch. And never in my life did I think I would see our great DOJ turn into a politicized weapon to be wielded by an investigation to attack political rivals. I still hold the thousands of hardworking staff with high regard. But unfortunately, there are some within the department, in my mind, who have betrayed their oaths. And for that, you must be held accountable. I hold you accountable for the labeling of parents as domestic terrorists standing up for their proper education of their own children. I hold you accountable for the anti-Catholic memo. Imagine sending agents undercover into Roman Catholic churches because they were supposedly domestic terrorists. And I hold you accountable for unleashing a special counsel with a history of botched investigations on our current president's political rival. The department under your leadership, I am sorry to say, has become an enforcement arm of the Democratic National Committee. If there is a perceived threat to the Democratic Party, this DOJ attacks every single time. But when there are actionable threats against conservatives, this DOJ stays put. Violent protesters outside the Supreme Court justice's home, unpunished. Attacks on pro-life centers, unpunished. The two-tiered system of justice is clear, and it's clear to the American public. And the buck stops with the man in charge. That man is you. The actions of the DOJ are on you. The decline of Americans' trust in our federal law enforcement is on you. The political weaponization of the DOJ is on you. Attorney General, I need a simple yes or no to the following. Just yes or no, because we don't have much time. Do you agree that traditional Catholics are violent extremists? Yes or no?
Let me answer what you've said in that long list of statements, and I'll be happy to answer all of those.
Attorney General, I control the time. I'm going to ask you to answer the questions I asked.
You controlled time by asking me a substantial number of things. And
I didn't ask you those things. I made a statement. Attorney General, through the chair, I ask you, do you agree that traditional Catholics are violent extremists?
I have no idea what the traditional means here.
Catholics that go to church.
May I answer your question?
Yes or no?
The idea that someone with my family background would discriminate against any religion is so outrageous, so absurd.
Mr. Attorney General, it was your FBI that did this. It was your FBI that was sending, and we have the memos, we have the emails, we're sending undercover agents into Catholic churches.
Both I and the director of the FBI have said that we were appalled. That we were appalled by that memo.
So then you agree that they're not extremists?
We were appalled by that memo.
Are they extremists or not, Attorney General?
I think that...
Are they extremists or not, Attorney General?
Everything in that memo is
Are they
appalling.
extremists or not? I'm asking a simple question. Say no if you think that was wrong.
Catholics are not extremists. No.
Was anyone fired for drafting and circulating the anti-Catholic memo?
You have in front of you the inspection division's investigation.
Just tell me yes or no, please.
I don't know.
We have
the
no
answer.
time.
I don't know the answer to that. There's
Okay,
a
do you agree that
disciplinary
parents attending
process
school
that the
board
Attorney
meetings should be
General is not
categorized?
permitted
Should
to
parents
intervene
that,
in.
should parents that go to school board meetings and are very vocal about their kids' education, should they be classified as domestic terrorists?
Of course not, and my memo made clear that vigorous objections to policies in schools are protected
So it's no.
by the First Amendment.
The president this week accused you, not the president himself, his staff, and it was in the Wall Street Journal, and it was leaked out, of mismanaging the Hunter Biden probe. Do you agree? Yes or no? It was in the Wall Street Journal article. I'm not saying
I'm
that.
sorry. Do I agree with the Wall Street Journal?
Yes, and the information they released that said you botched this probe.
Yeah, I think I've dealt with the Hunter Biden investigation in the way I've told this.
Mr. Chairman, I yield my remaining time to you.
I appreciate it. The gentleman yields back. The gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman, and thank you, Attorney General Garland, for your decades of service to the Department of Justice, to our country, and to our Constitution. It's been truly honorable service, and I think the American public as a whole recognizes that. I was struck by and appreciate your opening statement in which you made crystal clear your fidelity to the U.S. Constitution and the rule of law, and your reaffirmation that the Attorney General is not the President's lawyer. This is a welcome change from the rhetoric and actions of some of your predecessors in the last administration when they appeared before us. As we all should know, the Justice Department works for the American people to prosecute crimes, uphold the rule of law and Americans' individual rights, and keep our country safe. And Congress, of course, has a legitimate duty of oversight. But the blatantly political and misleading rhetoric which we've been subjected to today undermines the seriousness of this committee's work and ultimately the legitimacy and core values of our American institutions. It's painfully obvious to anyone who cares about our Constitution that our colleagues have called this hearing not to conduct legitimate oversight, but to once again defend the indefensible actions of the disgraced, twice impeached, and now repeatedly indicted in multiple jurisdictions former president, and to distract from their inability to perform the most basic function of Congress, to fund the federal government. So they're baselessly accusing the U.S. Department of Justice of bias against the former president and his allies. But it's important to note that those who are noisily and shamelessly trying to subvert our justice system are the same ones who seem to have both the most to fear from those ongoing investigations and the most to gain politically and personally from impeding them. As others have noted, these attempts now include trying to defund the Office of Special Counsel, Jack Smith's office, altogether. I, like so many Americans, find this behavior contemptible and far beneath what we should expect from our country's leaders. Mr. Attorney General, why is it so important for both upholding the rule of law and maintaining public trust that our justice system be able to conduct investigations into wrongdoing free from political interference?
The criminal law can impose incredible sanctions on people. It can take away their liberty. That means due process has to be followed during investigations, and that partisan considerations not play a role. That civil liberties and civil rights are protected, and the only way that can happen is if prosecutors are permitted to go about their work without any external impermissible interventions or considerations.
Thank you. I did want to take the opportunity, since this is an oversight hearing, to conduct some actual oversight. And there was an important topic in your testimony, safeguarding the right to vote. During the previous administration, I asked department officials in this committee room what actions they were taking on this critical issue, and they couldn't answer me. So could you describe the efforts that your Department of Justice is taking to protect the right to vote, a fundamental pillar of our democracy?
Yes. The Congress, in the form of the Voting Rights Act and the Civil Rights Act, authorize the department to bring cases and to enforce the Constitution of the United States with respect to the right to vote. As I'm sure you know, in the Shelby County case, the Supreme Court eliminated one of our tools, Section 5 of the Voting Rights Act, but we retained Section 2, which the Supreme Court again endorsed in its last term. So we have brought cases in a number of jurisdictions where we felt that state laws unconstitutionally impinged on the right to vote. We have supported private parties when they've brought those cases, particularly in redistricting cases that violated the anti-dilution requirement of Section 2. We have a task force with respect to threats against election workers, because threatening election workers and stopping them from going about their work is a significant way in which the right to vote can be impinged. That's just a sampling.
And we certainly saw evidence of that in Pennsylvania during the last presidential election. So we really appreciate all those efforts. You know, I find this hearing very disturbing in that we have elected officials misleading the public, attacking the foundations of our democracy, trying to sow distrust on one of the most critical pillars of that democracy, the U.S. Department of Justice. It's unacceptable and it's un-American. Mr. Chair, I seek unanimous consent to enter into the record a fact sheet on the Department of Justice's work under Attorney General Garland's leadership to safeguard Americans' right to vote and protect our election officials and workers.
Without objection.
Thank you. I yield back.
Committee will be in order. Committee will be in order. Vacillated, please. Gentleman from Virginia is recognized for 5 minutes.
Thank you, Mr. Chairman. Attorney General.
Thank you.
On August 11th, 2023, you appointed Mr. Weiss special counsel. You wrote a letter to the House and Senate Judiciary Committees where you cited extraordinary circumstances requiring the appointment. You avoided answering the question when Mr. Bentz asked you. I'll give you another chance to answer it. What were those extraordinary circumstances?
I'm afraid I'll have to give you the same answer I gave before. I've gave as much as I can give, which is that he thought that it had reached a stage where it would be appropriate, that I had promised him that I would give him any resource that he needed, and that he asked for it. And to go further would go into a pending investigation.
Okay, let's talk about that authority. Back on March 1st, you told the Senate Judiciary Committee that Mr. Weiss had the full authority to bring cases in other jurisdictions if he felt it was necessary. On June 7th, Mr. Weiss wrote to the Judiciary Committee stating he had been granted ultimate authority over the matter, including responsibility for deciding where, when, and whether to file charges. But by June 30th, he had changed his tune and said that his charging authority was geographically limited, and it would be up to the U.S. Attorney's Office and then you to determine whether he can partner on the case, and if not, he can request special attorney status from the AG pursuant to 28 U.S.C. 515, and he had been assured that if necessary, he would be granted 515 authority in D.C., Central District of California, or any other district where charges could be brought. Let me ask you, is there some distinct legal authority known as special attorney status?
I'm sorry?
Is there some distinct legal authority known as special attorney status?
Yeah, Section 515 permits the Attorney General to sign an order to authorize a prosecutor to work in another district.
And if you had already decided that he had full authority, why did you feel it was necessary to sign that document?
I'm sorry?
Why did Mr. Weiss feel that he would need that extra authority if you had conveyed to him that he would have all that authority?
You'll have to speak with Mr. Weiss about that. I think his 3 letters are quite clear that he understood he would have the necessary authority and that no U.S. attorney could block him.
Okay. We asked you earlier about his request for this authority, and we need to know who he spoke to about this authority and when. Before he asked you in August, he had discussions about this with others at the department. Who did he discuss special counsel authority with, and when did he do that?
I'm not going to discuss internal deliberations of the department. I guaranteed that Mr. Weiss would have the authority that he needed, and the moment he asked for the authority, I gave it to him.
Did he discuss it with the Deputy Attorney General?
Again, I'm not going to get into discussions of deliberations within the Justice Department.
That is not a valid constitutional objection.
Well, that is a valid constitutional deliberation. It has to constitutional objection. It has to do with the ability of the Justice Department to do its communications, just as your deliberations with your staff and with other members are protected by the Constitution.
Detailing who had conversations and when does not implicate the internal deliberations at the department. The substance of those deliberations, simply detailing who and when, does not implicate those.
Yeah, I'm not going to get into the internal discussions of the department or who talked to who about what. Mr. Weiss has told this committee that he well understood his ability to bring a case wherever he wanted, and I have said that he had that ability.
Do you think that the extraordinary circumstances that you cited in the appointment have anything to do with the June 22nd and July 19th testimony of whistleblowers, Special Agents Shapley and Ziegler?
I don't think it has anything to do with Mr. Shapley, no.
Gentleman,
I'll yield to the chairman.
I appreciate the gentleman yielding. Mr. Garland, have you or are you investigating who leaked the information that appeared in the Washington Post on October 6, 2022 about this investigation, about the Hunter Biden investigation?
You're saying there was an October 2022...
October 6, 2022, Washington Post writes a story about the Hunter Biden investigation. I wonder, have you investigated who leaked that information to the Washington Post?
I don't know the answer to that question.
Has it been referred to the Inspector General? Do you know that?
I don't want my answer to suggest that there is or isn't such an investigation. I know that the Inspector General sent a letter to Congress explaining that he had an ongoing assessment with respect to the whistleblowers' charges. I don't know if that's what you're referring to.
Time the gentleman's expired. The chair now recognizes the gentleman from Colorado.
I thank the chairman and the ranking member for holding this hearing. Thank you, Attorney General, for your testimony, for appearing before us, and for your service to our country. I have great respect for my colleague from Virginia on the other side of the aisle. I'm a bit confused as to why they have zeroed in or focused in on this particular letter in such a myopic way, but your testimony, and I wrote down the words here, that the moment he, meaning the Trump-appointed U.S. attorney, Mr. Weiss, asked for the authority, I gave it to him. Seems pretty straightforward. And as you said, the letters that Mr. Weiss has written to this committee are publicly available, and we encourage anybody who's watching these hearings to certainly review those. As you said, clearly they're consistent with each other in terms of reading those letters collectively. I think it's important, Mr. Attorney General, to perhaps talk a bit about your record and your background in light of the various attacks, unfortunately, by my colleagues on the other side of the aisle. My understanding is that you served as a special assistant to the Attorney General of the United States early on in your career. Is that right?
As my first job out of being a law clerk, yes.
Your first job out of law school. You
Being
were
out of, after law clerk.
after law clerking, of course. You later were in private practice,
Yes,
and you left private practice to become a line attorney at the Department of Justice,
that's right, to be an assistant U.S. attorney.
an assistant U.S. attorney, a federal prosecutor, taking on organized crime cases, drug trafficking cases, violent crimes.
Yes, I don't know about the organized crime, organized drug trafficking, yes.
Following that service, you served in the Department of Justice as the principal associate
Attorney General.
Attorney General.
Deputy Attorney General, yes.
Deputy Attorney General. This is in the mid-90s.
That's right.
And in that capacity, you supervised a range of high-profile cases. Is that right?
Yes, they were high-profile
The
cases.
Unabomber case?
The what?
The Unabomber case.
The Unabomber case, yes.
The Atlanta Olympic bombing.
The Olympic bombing, yes.
The Oklahoma City bombing case.
Olympic, yes, that's
You
right.
received praise with respect to that latter investigation from the then Republican governor of the state of Oklahoma. Is that right?
Yes, who was a very good partner in the investigation with respect to Oklahoma.
You then were nominated and appointed to the federal bench, the U.S. District Court of Appeals here in Washington, D.C., correct?
For the U.S. Court of Appeals, yes.
Right. You were confirmed by a bipartisan majority. Over 20 Republican senators voted for your confirmation.
I'll take your word for it. I think that's correct.
You served on the bench for a significant period of time, ultimately becoming the chief judge.
Yes, that's right.
You left that position to return to the Department of Justice, where you had started your career.
Yes.
And you were confirmed into this position in which you now hold on a bipartisan basis in the Senate.
Yes.
I think it's unfortunate, Mr. Attorney General, that my colleagues on the other side of the aisle have conflated questions about various cases that the department has brought with impugning your integrity. And I can assure you that the vast majority of the American people don't share their opinion, and that my constituents, the folks back in Colorado, are grateful for your lifetime of service that you have given to this country. And I recognize that this is, I suspect, a frustrating exercise in terms of this particular hearing, because I suspect that you'd like to be talking about the prevalence of fentanyl in our communities and the work that the Department of Justice is doing to interdict it, the gun violence epidemic in our country, and the work that the FBI and other law enforcement agencies are doing to stop it. And my hope is that the next oversight hearing, perhaps those can be the focus, the bulk of the hearing. I'd be remiss if I didn't say one note about a rule that the Department of Justice recently promulgated. As you may recall, in 2021, March of 2021, I sent a letter to the Department of Justice requesting that the Department of Justice issue a rule regulating stabilizing braces. One of these braces was used, as you might recall, at a mass shooting in my community in Boulder, Colorado, where 10 Coloradans tragically lost their lives, including one police officer. And the Department of Justice issued a final rule earlier this year on this precise topic. Unfortunately, my colleagues on the other side of the aisle have made it their mission to overturn this rule. I wonder if you might be able to just elaborate a bit on how the rule was drafted and deliberated within the department.
Yes, well, that horrific event in Boulder was one of several examples of the use of attachment of a semi-automatic pistol to a stabilizing brace intended to permit its firing from the shoulder. That violates the rule, the congressional statute against short-barreled rifles being possessed without registration, anything under 16 inches. The reason for Congress's statute, which I think probably goes back to the Al Capone era, was the power of such a weapon and the ability to aim such a weapon when it's shouldered. All that was done in this rule was to make clear that if you convert a pistol into a rifle designed to be fired from the shoulder, you're subject to the registration requirement.
Thank you, Mr. Attorney General. I yield back.
The Attorney General has requested a short break, so the committee will stand in recess for a few minutes, and then we'll be back for the remainder of our members' questions. Committee will come to order. The chair now recognizes the gentleman from Arizona for 5 minutes.
Thank you, Mr. Chairman. Sir, is it the policy of your Office for U.S. Attorneys to use prosecutorial quotas?
I'm sorry, I'm having a little difficulty hearing.
Okay, I'll get right on top of this thing. Is it the policy of your Office for U.S. Attorneys to use prosecutorial quotas?
To prosecute?
Yeah, do you have any prosecutorial quotas system in place?
No.
None whatsoever. That'd be anathema to your office then, right? I mean, it's not a policy. So would you be...
We don't, correct, we do not have quotas.
Right. And so would it be consistent with that when you have a prosecutor said that he wants to prosecute at least 2,000 people who are alleged to have committed a certain type of crime?
So look, I think you're referring to the January 6th question.
I'm just asking you, would that be consistent with your office's policy if somebody said, we're going to get up to 2,000 people on a particular crime? Is that consistent with your policy?
I think what that U.S. Attorney was referring to was a prediction for how many more cases would still be brought because the court had asked how many more people have been
filed a letter with the
identified.
court saying that we're looking at upwards of 2,000. We've got 1,200 more that we think we're going to get. So you don't do that for anything else, right? So you don't have anything like tax fraud. You're not saying, okay, we're going to have so many people that we want to get for tax fraud, so many people we want to get for lying on federal firearms
If a
applications.
court asks us what the likely workload will be based on prosecutions and investigations that are pending, the U.S. Attorney is obligated to respond.
Did you guys provide any reference of the number of people you thought you would prosecute who were involved in the 2020 summer riots of the burning of the Portland courthouse while there were still people inside those courthouses? You didn't ever file with the court or anything, say, oh, we think we're going to have another 300, 400, whatever it may be, because you didn't file those charges, did you?
I'm sorry, I'm not following. I believe that
I'm sure you're not.
The number that you're asking about was
Let me ask you this question.
projection that the court had asked the U.S. Attorney to make.
Let's switch topics. Maybe this one be easier to follow, I suppose. Is it the policy of the DOJ to provide advance notice to subjects before conducting a search for evidence?
It totally depends on the circumstance.
If the circumstance were that you had a guest house where the U.S. Attorney, Deputy U.S. Attorney saying, well, we know that we suspect there's a lot of evidence there, but we're not going to really follow that up. And calls the attorney from the other side saying, we were going to do a search warrant. Would that be consistent with your policy?
Okay, again, I know this is no hypothetical, and I don't know the facts of this case, and I don't know what happened, and I believe the events you're talking about, as reported in the press, occurred under the previous administration. So
no, that event didn't happen in the previous administration. Let's talk about that. I mean, you keep saying this happened in the previous administration, but let's talk about this for just a moment. You keep saying, I don't know what happened there, but I'm going to opine when it happened. Do you see the fallacy of that, the inconsistencies? I don't know when it happened. I don't know what happened because I'm not involved, but it happened under the previous administration. That's so logically fallacious.
I'm sorry, I'm not following what's
I know you're not following.
It.
So the question is, you've got one of your deputy U.S. attorneys calling the attorney on this side saying, look, we're going to go to these two places, probably go in the next couple of days. And of course, then ultimately the search warrant is called off. I just want to know, is it consistent to call up people where you know that they've got boxes of information, or you suspect they have boxes of information? That's why you got the warrant. That's why you're going to go look. And you give them a heads up so they can move those boxes of information. Would that be consistent with DOJ policy?
I'm just going to say again, you're asking me actually to comment about allegations in a particular case about which
No, I'm not. I'm
context.
asking you, is that consistent with your overall policy? Forget Delaware and what they did and that they actually did that. Let's just talk about generic policy.
I'm sorry, I thought you were asking about Mar-a-Lago. I may not have understood then. I'm sorry.
Yeah, la-di-da. So when we're talking about this, when we're talking about your general policy, is it your policy? Is that acceptable when you suspect that there are movable items to call up and say we're going to be there to look?
Yeah, There's no policy on this question. The strategy and tactics to be used to preserve evidence are left up to the investigators and offices on the ground. Sometimes it would be a serious mistake to call up. Sometimes it would not.
And here, once again, you don't know what happened in the Hunter Biden case because that's somebody else is doing it. But you can be sure of the timing of when all this took place. That is one of the biggest oddities of your testimony today. I yield back to the gentleman from Colorado.
Gentleman's time has expired. The chair now recognizes the gentlelady from Pennsylvania.
Thank you, Mr. Attorney General. Thank you for your decades of faithful service to our country, to our Constitution, and to the rule of law. Thank you for putting up with this today. The American people are watching. They know what's going on here. This is a gross misuse of your time, your team's time, and our time. It is a shameful circus. It has a goal. The goal is to spew lies and disinformation, ultimately to tear away at the confidence of our independent institutions, in your case today, our very important Department of Justice. That's the exact MO of a former president. Tear away at the confidence of our independent institutions, whether it's our electoral system, the Department of Justice, the judiciary, and independent news media. The American people are watching this sham. But it's not just a circus, it's dangerous, and you know that, and you have mentioned that. I believe that these fictions and fantasies are dangerous. Dangerous for you and the 115,000 public servants with whom you work. Dangerous for national security. Dangerous for communities' security. Dangerous for the rule of law and our Constitution. All at the same time of a looming shutdown. The other side of the aisle cannot govern. And so they have this hearing, which was supposed to be oversight, and use it as a big distraction because they are failing to govern. Imagine if we go into a shutdown. What does that say to your members of your department? What does it say to our service members, U.S. troops who would be training, fighting without pay and without confidence in this country's governing ability? It's a great distraction. So let me pivot to something I care about, and I know you and your department cares about. It is Recovery Month. And for families like mine with a member in recovery, every month is Recovery Month. So I thank you for what you are doing on the fentanyl crisis, the overdose crisis that has claimed 110,000 lives in a single 12-month period. 300 souls a day, every day. Souls who have died while we were in this hearing, every day. What is the department doing to combat the trafficking, to combat the amount of fentanyl on the ground? As DEA has said, there's enough fentanyl on the ground right now to kill this entire population multiple times over. Tell us about your important work in fentanyl.
Well, Congresswoman, let me begin by saying I share your personal concern and grief over this. I have met with the families of children, of teenagers, of elderly people who have become addicted to fentanyl and who have died from fentanyl. Everything you're saying is correct, and it's a catastrophe for the country. So as a consequence, the Justice Department has poured its resources, particularly from DEA, with FBI assistance as well, and with fugitive arrests by the Marshal Service and with gun tracing by the ATF into the entire process by which fentanyl reaches the United States. So we have sanctioned the precursor companies in China. We have indicted some of them for their violations. We have arrested some as far off as in Fiji and brought them back to the United States. We have traced these precursors to Mexico, where they are made into the fentanyl pills. Fentanyl costs about 10 cents to make. It can be sold on the street in the United States between $10 and $30. You can see what the enormous profit motive is here. So we must stop the cartels themselves. I have, as I said, traveled to Mexico twice in order to work with our counterparts in the military and law enforcement there.
I thank you for all of that. I want to just pivot once, and I want to do anything I can to partner with you on this issue so that we stop losing people. I traveled recently with the Foreign Affairs Committee to The Hague, met with the extraordinary folks, the top prosecutor and his able team. They were very complimentary of the Department of Justice and your work. Can you tell us about your important role, or America's important role, in war crimes, especially in light of your powerful history?
Yes, I'm happy to. So I've traveled to Ukraine twice and to meet with the Prosecutor General there. And I'm going to meet with him again this week here, and he has met with me several times here. The Justice Department is pursuing the war crimes from Russia's unlawful and unjust invasion of Ukraine to help to investigate war crimes over which we have jurisdiction, to help the Prosecutor General in Ukraine investigate those prosecutions. I was, I believe, the first cabinet member ever to visit The Hague, the International Criminal Court of Justice, and to meet with Karim Khan, who is the chief prosecutor, to talk about our cooperation in respect to the investigations that they are doing. I've assigned a Justice Department prosecutor to the investigatory body that's been set up in The Hague for the crime of aggression. And she is there now working with the ICC and with Europol and Eurojust. And I've assigned a prosecutor to our embassy in Kyiv to work with our ambassador there and to work with the Prosecutor General's office there.
I thank you, Mr. Chairman, for allowing that answer to go on, because it is critically important. America is indispensable, and your work is indispensable. Thank you, sir.
Time of the gentlelady has expired. The gentleman from Wisconsin is recognized.
Mr. Attorney General, do you support the consent decree that I believe was put in place in the city of Minneapolis?
I'm sorry, do I support the?
Do you support the consent decree that was put in place with the police department of Minneapolis?
One was put in place by the federal government, yes.
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 Do you support fewer cops on the street?
Do I support?
Fewer cops on the street?
No, I don't support fewer cops on the streets.
That's what's happening as a result of what's happening.
I don't think that's a consequence of the consent decree.
Do you support?
Minneapolis has been losing police officers for many years.
Yeah, do you support more crime?
Do I support more crime?
Yeah.
No, I don't.
So there was just a hearing in Minnetonka, Minnesota, a tiny suburb of Minneapolis, just I think this last week, where they're beside themselves with the amount of crime that continues in Minneapolis since the riots of 2020. And I would point out to you that I had an officer in my district. I lived right across the border in Wisconsin, or that's where my district begins. A police officer was shot to death as a result of a weak-on-crime prosecutor in St. Paul and Minneapolis, Minnesota. Guy served only 4 years for a violent crime. Do you think that that's a problem?
If an officer was shot to death, that is certainly not an appropriate sentence. That's outrageous. Let me be clear, we are doing everything we can to assist Minneapolis. We have a very aggressive U.S. attorney who's brought a number of RICO and Vicar cases.
Let me continue.
Extraordinarily successful.
I got a real short period of time here.
Sorry.
In regards to disrupting drug networks, why do you think there's so much fentanyl coming into the country?
Because it costs 10 cents to make, and it can be sold for $30.
So Sheriff Mark Daniels from Cochise County, Arizona, sat right where you were at a few months ago, and under oath he said, the reason there is such a drastic increase in fentanyl coming into the country is because on January 20th of 2021, open borders policies were announced by President Biden. Have you expressed concern about those open borders policies that have led to this rapid increase in the amount of fentanyl coming into our country?
I can't associate myself with the conclusion reached by the sheriff, although I can certainly commiserate with the concerns.
So the sheriff is incorrect.
Look, the cartels in Mexico are bringing this, are causing this drug to be transmitted into the United States, and we were doing
Terrific.
everything we can to eliminate that incentive.
Yeah, you're not going to do it on doing that. Mr. Chairman, just so we're real clear here, this is the same answer we received from Secretary Mayorkas a couple months ago when he was in denial about a sheriff who lives, one of the most reputable sheriffs you'll find in the United States of America, sitting down there on that southern border. He sees it every day. He saw it working in 2020 because he told me when I was down there. And now he says, it is not working, and it started January 20th of 2021. You can pretend that you're dealing with fentanyl. You're not, because the borders are wide open. Do you believe, I'm going to shift to combating gun violence. Do you believe that a prohibited person that acquires a gun illegally and disposes it in a dumpster where a criminal or an innocent child could gain access to it should be prosecuted to the full extent of the law?
This is no longer a hypothetical question. You're referring to a specific case which is now in judicial determination before a court of law. It's not appropriate for me to comment on that case.
So, for the record, Mr. Chairman, let's understand that the same prosecuting attorney who is now the special counsel gave a sweetheart deal to that person. And yes, you are correct. We're referring to the president's son. He got a sweetheart deal, and the judge was smart enough to smell a rat when she saw it, and she said, you guys go back to the drawing board. That same special counsel is in charge of this investigation. Isn't that correct, Mr. Chairman? Absolutely. I want to close real quickly with this. There was a World Naked Bike Ride in Madison, Wisconsin, just a couple months ago, and I sent you a letter 2 months ago asking if you had a problem with that because it exposed a 10-year-old girl by the race organizer, the bike organizers, to pedaling around Madison, Wisconsin naked. Do you think that's a problem? And why did you not answer our letter from 2 months ago?
I'm sorry, I'll have to ask the Office of Legislative Affairs to get back to you about this.
Does it typically take 2 months to be able to answer questions like this?
It sounds like you're asking about a question about state and local law enforcement. We get hundreds and hundreds and hundreds of letters. I'll ask the Office of Legislative Affairs where that letter is.
State and local law enforcement would not act. We were hoping you would. It's obvious you're not. I yield.
Gentleman yields back. The gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman, and thank you again, Mr. Attorney General, for joining us and for your patience with this questioning. I'm honored to represent a diverse community in North Carolina. Wake County has worked to welcome people of all backgrounds, ethnicities, and religions. The growth and success of my district in the Research Triangle Park depends on our commitment to celebrating the many cultures that contribute to our community. Unfortunately, over the past few years, these very communities that have contributed so much to my state and my district have found themselves under attack. Jewish leaders in my district have received threats to themselves and their synagogues as recently as last month. HBCUs across our state have locked down in response to bomb threats. Asian Americans in North Carolina and throughout the country have found themselves facing slurs and threats spurred in large part by the racialized language about the COVID-19 pandemic. The Southern Poverty Law Center reported in late 2020 that the number of white nationalist groups grew 55% between 2017 and 2019, noting that the rise in hate-based attacks coincides with the growth of the white nationalist movement. And the Anti-Defamation League relatedly found that white supremacist propaganda incidents occurred over 14 times per day on average in 2020, with a total of 5,125 reported cases, nearly twice the number of cases reported in 2019, and the highest number the ADL has ever recorded. This dangerous trend has continued in the last few years and has recently included
as active clubs have been increasing in their number and prominence. These active clubs started popping up in late 2020 and are a network of white nationalist groups that see themselves as fighters in training for an ongoing war against a system they claim is deliberately plotting against the white race. As Attorney General, I am deeply interested and concerned about the rise of these clubs, threats of violence, and actual violence, and wanted to know if you're familiar with these activities and what your department is doing to counteract them.
So I'm not familiar with the specifics of those clubs, and I will certainly look into what the department is doing in that respect. Very soon after I came into the department, I saw the spike in hate crime threats that were being made and in actual acts of violence. I directed the department to develop a strategy for responding to that. 30 days later, that was pretty much coincident with Congress's passage of the COVID No Hate Act. And we have now fulfilled, I think, all of the obligations under that act. We have task forces set up to investigate and prosecute hate crimes, both as hate crimes and where they satisfy the requirements as domestic violent extremism or as domestic terrorism. We have brought dozens of cases against people who have made these threats, as well as, in particular, those who have attempted to carry them out. And as you know, we have a prosecution pending in Buffalo with respect to the horrendous killing of Black Americans in the Tops grocery store by an avowed white supremacist.
Thank you very much, and thank you for your efforts in this regard. On a different subject with my last 45 seconds, North Carolina also saw the impact of cyber crimes with the Colonial Pipeline. Yes. And I'd like to know how your office is counteracting any cyber attacks and dealing with people who perpetrate them.
Yeah, so we are vigilant to the risk of these kind of cyber attacks. In that case, these were criminal gangs affiliated in Russia, resident in Russia. Fortunately, we had available intelligence from Section 702, which we were discussing a little bit earlier today. I have to say that's one of the principal sources of our ability to fight these kind of cyber attacks, whether they are criminal or whether they are launched by nation states, whether they are attempting to get ransomware and create ransom, whether they're simply trying, or also simply trying to exfiltrate our information, or whether they're trying to prevent our computers from working at all. The Justice Department has established a cyber task force for this purpose, a ransomware task force, and we are recently working on cryptocurrency in exactly the same way.
Time of the gentlelady has expired. We want to try to move quickly.
Thank you. I yield back.
Attorney General, because we got votes and then we got a
of course.
Majority conference. The gentleman from Colorado is recognized.
I thank the chairman. Mr. Attorney General, welcome. And my friend and colleague from Colorado outlined your biography, I thought, very well. But he left out 2 points that I'd like to mention. One is, not only did you lead the prosecution of the Oklahoma City bombing case, but in that case, the death penalty was asked for and actually received, and Timothy McVeigh was executed. Not exactly a Democrat priority to seek the death penalty in cases, but you did so because of the rule of law. You did so because the facts and the law demanded that you did so, and you followed the facts and the law in that situation. The other issue I wanted, or example in your bio that I wanted to point out, is my understanding that in your conference room, you have a portrait of Elliot Richardson. And the reason you have a portrait of Elliot Richardson is because he demanded that the Department of Justice stay independent from the Nixon administration. He had the backbone to stand up to the President of the United States and make sure that the Department of Justice would not become the government's lawyer. You put that portrait there soon after you became Attorney General because it was a signal. It was a signal to the world that you wanted to be known in the same way that others that had come before you were known. And frankly, one of the reasons I respect Attorney General Barr so much is because after January 6th, he made the very difficult decision to walk into the president's office and tell the president the election was not stolen. We have looked at this. And for that reason, he resigned before January 20th when power was turned over. But Mr. Attorney General, you're unable to answer some questions here, but I'll answer them for you. Do you know what people would have said if you had asked for U.S. Attorney Weiss's resignation when you became Attorney General? I'm sorry, U.S. Attorney, yeah, U.S. Attorney Weiss's resignation. They would have said that you were obstructing the Hunter Biden investigation, that you were firing a Republican appointee so that you could appoint a Democrat to slow walk this investigation and lose the leadership of that investigation. If you had made the same decision a year later because you were frustrated that the prosecution wasn't moving fast enough, they would have again said that you were interfering with the prosecution. If you, when U.S. Attorney Weiss asked to become special counsel, if you had made the decision then to appoint someone else to special counsel, people would have criticized you because you would have been taking someone out of the investigation that knew the facts, that could lead the investigation, and put someone in who would have had to come up to speed on the investigation and wouldn't have allowed major decisions to be made until they came up to speed. So in three different opportunities where you could have acted, you would have been criticized either way, whether you acted or did not act in that situation. Far from slow walking, really once the Trump administration decided that that was the person leading the investigation, your hands were tied. You didn't have the opportunity to make a decision on the leadership of that investigation. But speaking of slow walking, I appreciate your reference in your opening remarks, your written opening remarks, to the Department of Justice strongly supports efforts by Congress to promote competition in digital markets by passing legislation to prohibit certain anti-competitive practices by dominant online platforms. You can't say who they are, but I can. Apple, Amazon, Facebook, and Google are monopolies, and they have been harming this country and harming competition in that particular market for years. And Congress for 5 years has been investigating and offering bills on that subject. They spent $250 million, according to reports, in the last Congress to defeat those bills. And now we do nothing in this Congress to try to deal with that very serious issue. In fact, there are efforts, I'm told, over in the Senate, and I use the word effort and Senate very carefully in the same sentence, but there are efforts in the Senate, S 2321, to take $50 million in funding for the Department of Justice Antitrust Division, and it would be an 18% cut, and to move that money to the General Department of Justice Operations Fund to try to further cripple the efforts that are going on in court. The state attorney generals and the Antitrust Division and Federal Trade Commission are doing a great job jointly in trying to combat the scourge of these monopolies. My question to you is, will you make sure that the Antitrust Division is properly funded so it can continue this very serious effort at stopping these monopolies from harming our children, from harming competition, and from further strengthening China's position in this area?
Yes, I absolutely will. And one of the first things I did in the first budget opportunity we had was to ask for more money for the Antitrust Division than had been given in quite a long time, and to ask for the fees that are paid for purposes of merger analysis be given to the Antitrust Division directly rather than to go into a general fund.
Thank you. I yield back.
I would just point out for the record that Attorney General Barr left the Trump administration on December 23rd, 2020, not between January 6th and January 20th, 2021. With that, I recognize the gentlelady.
Mr. Chairman, could I'm sorry, since you mentioned monopoly, could I also enter into the record this article about the MasterCard Visa duopoly by Proactive and their target of a bipartisan bill to reform this monopoly? Could I insert that into the record, please?
Yeah, without objection, unanimous consent accepted. Gentlelady from Missouri is recognized.
Thank you, Mr. Chairman, and thank you for being here, Attorney General Garland. St. Louis and I are here today to make clear what it means to promote equal justice for every person in this country. Attorney General Garland, you often speak about your commitment to supporting civil rights and the rule of law. But I have concerns about whether the department under your leadership is doing the absolute most it possibly can to advance these goals. In the limited time I have, I want to share my concerns about specific issues with you directly and to make clear the steps that I believe that the department needs to take. First off, as this hearing has shown, a small number of the department's cases get an outsized level of attention in politics. But the reality is you preside over most of the federal system of mass incarceration. And every day in courtrooms around the country, including St. Louis, prosecutors who ultimately report to you are continuing to disproportionately prosecute disproportionately Black and brown people for disproportionately low-level immigration and narcotics and firearm offenses. And under your watch, the federal incarceration rate has increased for the first time in nearly a decade. Meanwhile, corporate crime enforcement is lower than it was during the Trump administration. The department needs to rethink its entire approach to prosecution, but let me also say I thank you for what you're doing with the insurrectionists. And I urge you to take specific steps towards ending mandatory minimums and prosecutory misconduct waivers and actively supporting alternatives to incarceration, funding federal public defenders, use of clemency power, and reporting on disparities in federal prosecutions. I'm also deeply concerned about the Bureau of Prisons. Director Peters is not doing enough to address the rampant issues of abuse and mismanagement at the Bureau, which affects both correctional staff and people in custody. It is shameful that solitary confinement has increased in the Bureau of Prisons during the Biden administration, despite the president claiming he supports ending it. We need to see more from the department across the board on Bureau of Prisons oversight. And you should implement the president's commitment to end the torturous practice of solitary confinement once and for all. I'm also incredibly disheartened that the department has continued to pursue the death penalty despite the president's pledge to end it. I urge the department to reverse course, including by dismantling the federal death chamber in Indiana and advocating for the commutation of the sentences of everyone on federal death row. I'm also still waiting to see any meaningful progress on the commitments that Associate Attorney General Gupta announced in June 22 around the enforcement of Title VI and the Safe Streets Act. I'd also like to, and I'm going on and on, but I'm taking my time. I also like an update on when the department will respond to the Oversight Committee Democrats' letter from June 2021 about the memo issued by the Trump administration's Office of Legal Counsel concerning the Equal Rights Amendment. That deeply flawed memo is preventing the Archivist of the United States from publishing the Equal Rights Amendment as the 28th Amendment. I know that OLC issued a short clarification after you took office, but the wording was not a clear repudiation of the Trump-era memo. I urge you to fully withdraw the Trump OLC memo, which is baselessly obstructing constitutional gender equality for all. Finally, I cannot overstate how shocked I am by the targeting of protesters who oppose the construction of the Atlanta Public Safety Training Center, or Cop City, and I urge the department to investigate these obvious violations of civil rights. These may all seem like unrelated issues, but to me, to my constituents, to countless advocates, and to people who are most directly impacted, they are interconnected, and they all speak to whether the department under your leadership will advance justice or simply pay lip service to it. Given the limited time that we have, I don't expect you to comment on all of these issues, but I have a question. Will you commit to working with me in my office on these issues, including having your staff promptly, by writing your position and sending that to us, reaching out to us about all of the issues that we just spoke about?
I'd be happy to have the Office of Legislative Affairs to work with your staff. I want to say I could not be prouder of the civil rights record of this department. It is the fundamental basis for why the Justice Department was founded. We have a history of also being obviously involved in the 1960s When I came to the Justice
And
Department.
I'm going to stop you. I'm not disagreeing with any of that. I just want you to understand where I'm coming from, the things that I would like to see. I don't mean to cut you off, but I need to reclaim my time. Finally, I want to remind everyone yet again that this is what good faith oversight looks like, not the Republican playbook of running interference for a twice impeached, 4 times indicted white supremacist demagogue who would rather overthrow our democracy than admit he lost an election. Thank you, and I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank the chairman. Thank the Attorney General for being here before us today. On October 21st, 2021, before this committee, I asked you about Mr. Scott Smith, a father in Loudoun County, Virginia, who was arrested at a school board meeting where he questioned the rape of his daughter in a bathroom in the public school there. You said at the time you were unfamiliar with the case. Are you now, yes or no?
I'm only familiar to the extent I've read about it in the press.
You sent a memo on October 4th, 2021, directing the FBI and U.S. Attorney offices to address, quote, harassment, end quote, of school boards. Yes or no?
Sent a memo to address violence and threats of violence in connection with school personnel.
Directed at school boards.
Not directed at school boards, directed at school personnel, school administrators.
Throughout the country as a priority for the federal government, for the United States Attorney's Office. That followed a letter on September 29th, 2021 from the National School Board Association to President Biden and emails from the National School Board Association Director Chip Slavin to the White House, in which the White House asked for specific threats. And one of the examples was Scott Smith. Subsequent to our hearing 2 years ago, 26 states left the National School Board Association, and Slavin resigned on November 23rd of 2021. Last week, Mr. Smith was pardoned by Governor Youngkin. Do you think the governor was correct, yes or no?
Pardon authority belongs to the governor.
You don't have an opinion on whether the governor was correct?
I don't know the facts of the case, so I'm not in a position to make.
Have you rescinded the memo that you issued in 2021, yes or no?
What we're discussing.
Have you rescinded the memo, yes or no?
What we're discussing here occurs.
Does the memo still exist? Is it still going, yes or no? Has it been rescinded?
The memo was intended to have meetings within 30 days.
Has it been rescinded?
The 30 days have finished. Nothing has happened in more than a year and a half with respect to that
But it
memo.
has not been rescinded, it has not been pulled back.
Nothing to rescind.
Despite evidence that has come out from the National School Board Association, commissioned report that White House officials discussed this with DOJ more than a week before the letter was sent. The NSBA apologized. Have you apologized? Yes or no?
I've testified 7 times since that original memo.
Well, it's the first time you're back here since we talked about it.
I'm sorry?
It's the first time you're back here in front of us. Have you apologized for putting that memo out that implicated Scott Smith as a domestic terrorist, something the governor of Virginia has now pardoned him from all of these accusations?
The memo said nothing about him, nothing about parents being terrorists, nothing about attending school boards.
So the answer is it's not been rescinded and you haven't apologized for it.
The answer is that's not an
labeling an American citizen a domestic terrorist in a memo and referring to it and a memo that's built on the back of that. But now we had this compliments being driven to the Civil Rights Division. Let's talk about Mark Houck in Pennsylvania, a father who was arrested with heavily armed federal and local law enforcement in front of his wife and children. This after Mark Houck's lawyers had said he would appear voluntarily. Local authorities investigated, found no case. Mark Houck was arrested by the FBI for FACE Act violations. The jury met for an hour. Houck was acquitted. Now, when I was in federal court, I don't remember that being my result very often. In fact, I don't remember happening at all, where we took it to a jury and it was acquitted after an hour. Did you investigate this or question the United States Attorney why they wasted resources for such an obvious result? And can you explain, yes or no, that that was a good use of the Department of Justice's authority?
The Justice Department respects the jury's verdict. The decisions in that case were made by agents and prosecutors on the ground.
Are you concerned that enforcement of the FACE Act has been biased towards pro-lifers over anti-life protesters, 126 to 4 by our count? And we're asking information to be able to track down the information of such prosecutions, but 126 times against pro-lifers versus 4 times for people who dare to question the issue of life. I'll leave that out there just to say that is the Civil Rights Division at play. Meanwhile, we've got the very liberal progressive groups being targeted as well. Senator Cruz and I sent a letter to you asking for information about how the FBI informant had gone to a liberal group's pro-life meeting, and yet we didn't get any response from you. So I'd ask if you would respond to our letter that we sent back in March asking about FBI infiltrating such a meeting.
I don't know what you're referring to, but I will ask the Office of Legislative Affairs to look into this letter.
Thank you. Finally, our tax cases require approval by Main Justice no matter what district has venue, yes or no? Do tax cases as a general matter require approval by Main Justice no matter what district has venue, yes or no?
It depends on the circumstances in the example that I know you're referring to.
Generally speaking, yes. Since Main Justice runs tax division, yes or no? Main Justice runs the tax division.
In the Hunter Biden case, I assured Mr. Weiss that
That's not what I'm asking about. I didn't ask it. I haven't mentioned that guy's name. I didn't. I very simply asked a very simple question. Okay. Do tax cases require approval by Main Justice as a general matter?
Most of the time, but not when the Attorney General has granted authority to a U.S. attorney to do what he thinks is best.
And in a turf battle, if tax division approves changes...
Mr. Chairman, point of order.
I mean, I recall my colleague in Texas having a minute and a half of additional time.
Gentleman's time has expired. The chair now recognizes the gentlelady from Texas.
Thank you, Mr. Chairman. And Attorney General Garland, thank you first and foremost for your public service and your dedication to justice. I'm delighted to see you here today. Thank you for appearing before us. I represent El Paso, Texas, a community right on the U.S.-Mexico border. And so we have been witnessing firsthand the abuses at the hands of Governor Greg Abbott through Operation Lone Star, which began in 2021. Governor Abbott has deployed state resources and Texas National Guards members to the state's border with Mexico. And Operation Lone Star has created border management challenges. It's resulted in countless humanitarian and due process violations for migrants. It's harmed guardsmen assigned to the mission. It's cost the state billions of dollars, and it has completely undermined the federal government's authority over immigration. I sent you a letter, my colleagues and I from Democratic colleagues from Texas sent you a letter in July about Abbott's floating barriers. I know that that is now that case is going through appeal. But we have also learned that the National Guard shot, a guardsman shot at a Mexican national across the Rio Grande. And in September, on September 1st, I sent you a letter asking that the DOJ investigate that. We also know that Governor Abbott, we've learned from whistleblowers that he has ordered National Guardsmen to prevent migrants from turning themselves in to CBP, has even ordered that they push people back into Mexico. And Mr. Chairman, I'd like to unanimous consent to enter into the record an El Paso Times article from earlier this week. Texas National Guard orders hundreds of asylum seekers on U.S. territory back into Mexico.
Without objection.
This, in addition to Governor Abbott separating fathers from their children and their families, it's egregious what is happening on the border via Operation Lone Star. Attorney General Garland, are you able to speak to any responses the department has had to Governor Abbott's blatant undermining of federal immigration authority?
I can obviously speak on the buoys question. When we brought suit under the Rivers and Harbors Act for the interference with navigable waters. That case is still under adjudication in the district court.
I understand that. There are other issues, and want to make sure I flag them for you today at this hearing, but would also like for your folks to take a close look at the investigation that I've requested. And I will be sending a follow-up letter after what we've learned just this week from the El Paso Times. Switching gears, I do want to offer you an opportunity for some rebuttal, because what we've seen from some of my colleagues on the other side of the aisle is their penchant for performance for Twitter and for other news programs. Mr. Attorney General, we've heard a lot of accusations regarding some U.S. attorneys' offices not partnering with Mr. Weiss and hypotheticals about what that means. Can you please explain the difference between partnering with a U.S. attorney's office and acting as a special attorney or special counsel?
I can talk about it, obviously, in the abstract and the theoretical. It's a normal process of the department if prosecutors from one area of the country and has a case that has significance in another, to speak with the U.S. attorney in the other district, to find out what the policies of the district are, to find out what the practices are, to see how judges in that district react to different kinds of charges. Sometimes decision is made to partner together in those investigations, and sometimes a decision is made for the U.S. attorney from the other district to have his or her own people bring those cases. I have personally been involved in, I think, 3 those cases during the period when I was an assistant U.S. attorney, and over my entire career, I have been given 515 authority twice myself. For this purpose, it is not it is just a mechanical question of what courts require in order to make an appearance.
Thank you so much, Mr. Garland. Again, appreciate your public service to the American people. Mr. Chairman, I yield back.
Gentlelady yields back. The gentleman from Alabama is recognized.
Thank you, Mr. Garland, for being here today. Every time I'm in my district, constituents are concerned about the weaponization of government, them being selected because they happen to be conservatives. And I think on your watch now, the DOJ actually is at a mid-30% approval rating. And, you know, every time the DOJ goes after Trump, he goes up in the polls. I think the American people are starting to wake up to what's going on, and I think it's fairly obvious. And the first question I have is, I understand now that we know that thanks to an FBI whistleblower, that the FBI received information on Americans from Bank of America. Specifically, Bank of America sent the FBI a list of customers who made transactions in the days on and around January 6, 2021. My question for you is, did the Department of Justice acquire any geolocation data from January 1st, 2020 through December 31st, 2021? Yes or no?
I'm sorry, did you say locational data?
Geolocational data.
Geolocational, I believe everything that was done with respect to geolocational data was disclosed in the public filings in the January 6 cases. I don't have that at my fingertips, but this is a matter of public record.
Do you remember any specific analyses that you may have done with that data?
I'm sorry, I can't hear.
Any specific analyses that you may have gotten from that data? Was there anything particular you were looking for, Mr. Attorney General? Like, did they exercise their rights? Did they maybe buy a firearm?
I'm sorry, I don't know anything about the second thing. The purpose, as I understood of the location data, was to determine whether people who claim they weren't inside the Capitol actually were inside the Capitol.
Well, where did the, I guess the question is, to your knowledge, and where the DOJ, geolocation data from external sources, entities, or organizations, to your knowledge, did you receive that from external sources, or are you buying that data?
So I don't know the exact answer in general, but I believe with respect to January 6th, these were the results of subpoena as issued to telephone companies.
So you subpoenaed the telephone companies, then they got the data
Well,
from
this requires orders authorized by the court.
Does it concern you that, you know, we talked about Durham's report earlier, that he said that the FBI's activities were somewhat sobering. Does that worry you on your watch that the activities of the FBI have been called sobering now?
I'm sorry, I didn't understand. Who calls it sobering?
John Durham in his report. Did you read his report?
I'm sorry, who?
John Durham.
Durham?
Yes, sir.
I did read the report. All those events had to do with the Crossfire Hurricane investigation. Is that what
that was part of it, yes, sir?
Yes.
Were you concerned when he said it was sobering what the FBI was doing?
I think Mr. Durham, and I just want to make sure everybody understands, Mr. Durham thanked me for not interfering with his investigation. I had promised he would be able to go forward without interference, just as I promised Mr. Weiss. Mr. Durham's, and I did not interfere with his report. His report reported a lack of analytical rigor and a number of other problems with respect to the investigation. I think both the Inspector General made a similar comments, and Director Wray has made the same.
Thank you, Attorney General. I don't have a whole lot of time. I want to yield a little bit to the chairman, but is it a crime in the U.S. to question an election?
I'm sorry.
Is it a crime in the U.S. to question an election? Is that a crime?
I'm sorry. It's my fault. I can't hear. To request a what?
Is it a crime to question an election in the United States of America? It is a crime. Is it a crime for the U.S. citizens to say, We want to ask about this election, we want to question this election, we actually want to look into the election. Is that a crime when citizens just question an election in America now?
Again, I think you're asking not a hypothetical, but something specific about specific.
I think that's just general. I don't think that's specific. Elections have been questioned for decades past. Is that now a crime in America?
Did you say to ask questions about an election? Is that what
To
you
question an election.
said? To question.
Just to question the
it's
results.
It's not a crime to question an election.
Because I question the election results in 2020. And there are a lot of people in America that do. And they question the weaponization of government attacking American citizens. And so you, sir, have an issue with trustworthiness of the American people and with Congress at this point. With that, Mr. Chairman, I'm sorry, I'll yield 36 seconds.
No problem. Mr. Garland, did you consider, I just want to go back to this question, did you consider anyone else when David Weiss requested special counsel designation on August 8th?
No, Mr. Weiss asked to be made special counsel, and I did not consider an alternative. Of course, to have put in an alternative would have greatly disrupted an investigation that was already
I want
ongoing.
to be clear, he was the only one under consideration. It was either no special counsel, or if there was a special counsel, it was going to be the guy who presided over the investigation for the previous 5 years.
I thought about the possibility, what the consequences would be, both of not appointing him and trying to find somebody else at that time, but there was no other.
And you had no concerns. I mean, the whistleblowers have brought forward all kinds of concerns. Earlier, when someone brought those up, you said, well, those are allegations. I think they stand up well. They've been cross-examined for 4 hours by Democrats in the Oversight Committee. But there were two facts that can be questioned. Two facts about the investigation into Hunter Biden. Fact number one, they let the statute of limitations run. They let it expire. And fact number two, the plea deal fell apart. So I just wanted to make clear that the guy who presided over all that was the only guy under consideration for special counsel designation. Is that right?
Mr. Weiss is a person known for high integrity, for great experience in the prosecutorial realm, and he was appointed by the president.
That's fine. You can say all that. I appreciate what you're saying there.
I have no doubts about his abilities in this area.
He was the only one under consideration.
The question was whether to appoint someone. And I thought, I will say, what the consequences would be of trying to switch horses in midstream, but I did not consider any other person.
Okay, on July 10th,
no.
he wrote Senator Graham, and he said, I've had discussions with departmental officials. He said, I haven't sought special counsel status, but I've had discussions with departmental officials. And I don't know if this was asked earlier, who did he talk with then?
I'm sorry, you're talking about the letter that he sent to?
Senator Graham on July 10th.
Again, I'm not going to get into internal deliberations of the Justice Department.
Okay, fine. Is there one person, though, who's like the point person at the Justice Department for David Weiss as he now is functioning as a special counsel in this investigation?
Mr. Weiss is now subject to the special counsel regulations, which require urgent reporting under certain circumstances, require him to consult with numerous places within the Justice Department.
Fine, you're following the statute. God bless you. That's where it's supposed to happen. But you said there's reporting. Who does he report to?
Again, I'm not going to get into
Is it you?
I'm ultimately responsible.
Is it the DAG?
Mr. Weiss did not have to report to anybody. He was the supervisor and decision maker in these matters.
Okay. We have votes on the floor. We're going to have to take another break, Mr. Attorney General. We'll get back here as quick as we can, and we'll start with the Democrats.
Sure.
Committee will come to order. The gentleman from Maryland is recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, General. How are you?
Very well, thank you.
Good. I want to point out 3 things that you've said so far today because I want to emphasize these for the committee going forward. One was you said, we will not back down, we will not be intimidated. And the other thing you said, too, was the way to not interfere with an investigation is to not investigate the investigation. Now, I thought that was particularly apropos here because this committee has been doing exactly the opposite. We've been, under the chairman's leadership, investigating prosecutors all over the country in the middle of criminal investigations and sometimes post-indictment, sometimes pre-indictment, I think in an effort, frankly, to derail the prosecutions in those cases. And I'll start with the one, this is the Alvin Bragg effort. The chairman and 2 other committee chairs sent a letter, I think 2 actually, to DA Bragg. At the time he was still investigating former President Trump for potential prosecution. And then after he was indicted, they raised the issue again. And the concern I had on that front was multiple. One was, one of the letters that the committee chair sent was demanding information that potentially would have violated state law in New York, similar to the federal grand jury secrecy laws that we have in some of the matters that you govern, if he had complied with what the committee had demanded. But more importantly, I thought it was pretty clear-cut that it was an effort to undermine and derail DA Bragg's investigation. There was a similar version of that with DA Willis. I know there have been a lot of calls.
Would the gentleman yield for just a second?
Not at this point, although I'd be willing to make your letters a part of the record at the end of the... DA Willis in Georgia face similar calls. In fact, there are a number of prosecutors across the country, frequently they're in blue jurisdictions, cities, and red states, where they face pressure from usually state officials to curtail the way they're doing investigations. And in some instances, the state AGs have stripped them of their authority, even though they've been duly elected by citizens in those states. And then with respect to the Jack Smith investigations, at the beginning of the hearing, the chairman brought up Trump did everything DOJ asked him to do. Now, this is with respect to the search warrant. And I was appalled at what was said. Frankly, as the record bears out, both in the indictment and frequently in statements made by Mr. Trump himself, there were multiple efforts by the Department of Justice to reach out through the attorneys that represented Mr. Trump and have him comply and turn over documents. He refused to do so. In fact, the allegations are he, in fact, moved documents and tried to hide them so the Department of Justice couldn't get them. And that also led to the issue where Mr. Trump's lawyers ended up having to provide information and testimony about what had happened, which is highly unusual. But this scenario is highly unusual. And we know that's the case because former Vice President Trump, or Pence, and current President Biden had similar issues, but they complied with the request by the Department of Justice, turned over the documents, and so you didn't need a search warrant. But the news here is, I guess, if you don't comply with subpoenas from the Department of Justice, they will go get the information. They'll get a search warrant and go get it. And I know that because I've seen that in multiple cases in my career. There's no surprise, and there's certainly no 2 tiers of justice with respect to what was done in that instance. In fact, the fact that they took so long to do it, I think, is based entirely on the fact that he had been president. And then with respect to Mr. Weiss, because this is the most recent version, and I get why they're doing it. They want to try and build a case to impeach President Biden. The Weiss angle seems to be one of the ways they're trying to do that. But as Congressman Buck said, everything the department did with respect to Mr. Weiss was correct, because if the Biden administration had removed him when it came into power, there would have been howls from the Republican side that you were derailing the investigation because Weiss was already on it, and if you brought in somebody new, they'd have to start over again. And in fact, the Senate Republicans, as you testified earlier, sought your assurances that you would let him continue going forward, and as you've testified today, you've done exactly that. So I want to be clear. I know the committee's talking about bringing Mr. Weiss into testimony. They brought all these other people in to testify who are part of an active investigation. But it is a horrible precedent to be bringing in prosecutors in the middle of an investigation that's about to go to trial, that's already been indicted. That's not the way this committee should be doing business. We should allow prosecutors to move forward. If we got questions after the fact, we can raise them, as you pointed out. Mr. Weiss is going to issue a report at the end. Let's let them do their jobs and stop politicizing these cases. With that, I yield back.
Gentleman yields back. Gentleman from Indiana is recognized.
Thank you, Mr. Chairman. I yield to Chairman to clear the record on some issues.
Yeah, I thank the gentleman for yielding. Just two responses to the gentleman, my friend from Maryland. He said they'll get a search warrant and go get it unless it's Hunter Biden. Then they tip off the defense counsel. We know that happened. Second, relative to Mr. Bragg. Mr. Bragg sued me, and it went to court. And guess what the court said? They said we were right, and the guy we wanted to talk to, one of his prosecutors, came here and testified in this room. So the court was on our side there. Yield back to the gentlelady from Indiana.
Would the gentlelady yield?
No, I need to get to my question. Sorry.
All right.
Attorney General, you had a very moving statement about your grandparents coming here from Belarus to live in the country without fear of prosecution. I grew up in a very similar country, Ukraine now, and when I came here as a young person, I believed in the value as an American not to be afraid of my government. But I wanted to tell you, and I want to share with you and get your thoughts on that. Are you aware that a lot of Americans are now afraid of being prosecuted by your department? Are you aware about that? Are you aware of that? I'm just saying, are you aware or not?
I think that constant attacks on the department and saying
It's
that
not attacks. Well, let me give you an example.
I don't know
We talk
what-
about January 6th. People.
I'm sorry?
Here, some people came on January 6th. There probably were some people that came on January 6th here, that had bad intent. But a lot of good Americans from my district came here because they are sick and tired of this government not serving them. They came with strollers and the kids, and there was chaotic situation because the proper security wasn't provided. That's a question that was answered really why. Why we debated for 45 minutes on the floor and didn't stop the debate after the people broke into the Capitol. But these people came, they were throwing the smoke bombs into the crowd with strollers with kids. People were showed up, FBI agent to people's houses. You had in my district, in my town, FBI phone numbers all over the district. Please call that. People are truly afraid. I just want to make sure if you're not aware that you are. And this is a big problem when people are afraid of their own government. And I'll share some other things. We're talking about justice system. I don't question, you're probably not a bad person. I don't know you, but what I'll tell you, you're in charge of the department. And people right now feel, I look at Durham report and I call on the FISA violations of queries of millions of Americans, right? It's like KGB, but when I read Durham reports, we have this, you have a nice, playbook. First, let's have a special counsel, and then you don't have to answer any questions here. Then, let's extend slow walk investigation on Hillary Clinton, on Hunter. Everything is slow walk. We were very quick on Donald Trump, but you were very slow walk. Then, by the time, that investigation and its statute of limitation expired, and all of your agents need to be tested for amnesia. No one recalls anything. Okay, you probably should have as part of your hiring policy. So no one held accountable, which was egregious what happened, in that report. When I read about them, I can't believe it happened in the United States of America. This is my frustration. I'll be honest with you. Then it's very interesting, regardless what it is, even people in Obama administration raised concerns. How can President's sons be serving on, corrupt Ukrainian oligarchs? Do you understand that it actually can undermine the one Ukrainian effort and policy? I think these concerns were raised. The Obama administration didn't do anything about it. These people are dying right now, and Americans don't trust this president. So I want to ask you one thing. You know, as I don't need answer because I know you're not going to, but I think you're probably a good American and you care. And a lot of these people are so afraid they cover up this stuff, I think, in your department because they're embarrassed that what we became as a country, to say that what our Department of Justice became. That allows Russians to do propaganda in Chinese. It allows them to destabilize our country. That is danger to our republic. It is significant danger. And I have just one more question from you. You know, I mean, I agree on corporate crimes and FISA stuff, even with Democrats, that we need to do a better job. One more question for you. Do you believe that, you know, you talk about rights to vote, but do you believe that only U.S. citizens should be voting in this election and doing anything to make sure that only eligible people vote in elections?
Yes and yes.
Okay, I would like to see that, what you do. Thank you. Yield back.
Gentlelady yields back. The gentlelady from Vermont is recognized for her 5 minutes.
Thank you, Mr. Chair. General Garland, thanks so much for being here today. I know it's been a long day for you. Now, I'm relatively new to the committee, and I'm still getting my feet under me, but as far as I can tell, what we are doing here today is talking about a lot of conspiracy theories, and it's frustrating and tedious for those of us in the committee, but I can tell you it is absolutely maddening for my constituents back home in Vermont. We have so much important work to do to keep the government open. We're days away from a shutdown, and I just want to remind folks that we're in this situation because my colleagues across the aisle are reneging on a deal that a majority of their conference made along with their speaker. That's why we are in this situation. If they are successful in shutting down the government, seniors who rely on Social Security benefits will be impacted, thousands of Medicare recipients and applicants will be impacted, service members will stop receiving paychecks, veteran services will be curtailed. Those are the grim consequences from Republicans' inability and unwillingness to govern. I need to just start with that. Let's do some level setting here. Now, let's get to the real work of the DOJ and how Congress can help the agency better serve its mission. Gun violence continues to plague our nation. We see the wreckage every day on our television sets, on our computers, and in our communities. As a member of the Gun Violence Prevention Task Force, this issue is incredibly important to me and so many of my constituents. Now, I believe there's actual room for bipartisan congressional action on gun violence, at least in some areas. One of those areas, red flag laws. It's a great place to start. Vermont is one of 21 states that was able to pass red flag laws. These laws are working to keep guns out of the hands of people who are in crisis. And yet, many states did not even apply for funding from the Bipartisan Safer Communities Act to better implement red flag laws and to raise awareness about the program. In June 2021, DOJ published model legislation to help states craft their own extreme risk protection order. Now, Republicans continue to make unfounded accusations that these laws violate civil rights by taking guns away from Americans without any due process. Can you explain the due process protections that are put into place in the model legislation that DOJ proposed?
Yes, and I would start by saying, of course, there's room for bipartisan agreement, and the Bipartisan Safer Communities Act is a very good example. And that includes the ability to have funding for states that want to craft and put into place red flag laws. The requirement is that the red flag law include due process protections. So I don't know every element of the model legislation, but the general idea is relatives or friends of the person have to go to a court and get some kind of adjudication that the person is a danger to themselves or to others. This normally relates to mental illness problems. It may relate to some others. And so if a gun is taken away under those circumstances, there's then a right to appeal, to have a full hearing in order to adjudicate the question. That's I can't say I know every technicality, but I think that's about it.
No, I appreciate that. And it's especially important to states like mine, rural states that have real issues with the silent killers, domestic violence, and also suicide. And so these are instances in which red flag laws can really make a difference. Shifting gears here, I, along with Senator Warren and 20 of our colleagues, recently submitted a comment letter applauding the draft merger guidelines and urging agencies to finalize them. Corporate concentration remains a pressing problem for the U.S. economy, and I fear that we're falling behind in this area, and American consumers continue to feel the pain because of this. With the introduction of the draft merger guidelines, how does the department plan to ensure that future mergers and acquisitions do not stifle competition or harm consumers? Because that's often the pushback that we get.
Yeah, I think obviously the intention of the merger guidelines is to set forth the enforcement policy of the department. The different generations of the guidelines, which I hate to say it, go all the way back to the time when I was in law school, have been adopted and or been helpful to generations of judges. I've sat on at least 2 or 3 merger cases myself where we used some of the learning from the merger guidelines, and the current guidelines reflect really an adjustment to the current technology, two-sided platforms, network effects that simply did not exist at the time that the last set of merger guidelines were passed.
Thank you, Attorney General. Just briefly in closing, last year you spoke on the subject and said that DOJ's enforcement against corporate crime has waxed and waned, but it's waxing again. That is news to my ears. Thank you so much for your service. I yield back.
Lady yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. Mr. Garland, what is a confidential human source?
Well, it's an FBI term. I don't know all the technicality, but it's
Here, let me define it for you. It's in your own policy here. Okay. An individual who is believed to be providing useful and credible information to the FBI from any authorized information collection activity, and from whom with the FBI expects or intends to obtain additional, useful, and credible information in the future, all right? And whose identity, information, or relationship with the FBI warrants confidential handling. So these guys are individuals. You pay them $42 million a year. Did you know that? The IG said you're paying these sources $42 million a year. Did you know that?
I know informants are
It's $42 million a year. So do you believe that they're credible, they're valuable? The FBI's using these guys. We're paying them a lot of money. Would you agree with that?
I agree. Some are more
Very good. So they're credible. You're paying them a lot of money. You got a lot of them out there. So let me paint the picture for America. Hunter Biden joins Burisma in 2014. Burisma, very, very corrupt Ukrainian energy company. He has no experience in oil and gas. He admits it. He says, I don't have any experience. I know why I'm there. I have a dad. I have with me a document called the FD 1023. Have you seen this? You're familiar with it? Okay. It's used by the FBI, everybody in America. It's used by the FBI. It is a confidential human source reporting document dated June 2020. You're familiar with it. In this document, the FBI's confidential human source says Burisma, now the corrupt company, needed to keep Hunter on the board so everything would be okay. And according to the human source, they hired Hunter Biden to, quote, protect us through his dad for all kinds of problems. Mr. Garland, does that concern you? Okay, it should. I got limited time. Remember, your sources are credible, trustworthy, honest, and valuable. Are you familiar with Victor Shokin?
The document that you're...
Who is Mr. Victor Shokin? So I got 3 minutes left.
You want me to answer that?
Yeah, Victor Shokin. Who is he?
I don't know. Do you want me to answer
he's
the
the
first
prosecutor, folks. He's the prosecutor that was, he oversees all the corruption in Ukraine. We know there's corruption over there. For the American people watching, after a few months after Hunter Biden joined the Burisma board, Victor Shokin was named Prosecutor General for Ukraine to target corruption. And one of his investigations was into Burisma. In this FD 1023 document, the human source clarified that Burisma's CEO, the man in charge of Burisma, said he has many text messages and recordings that show he was coerced to make such payment to ensure Victor Shokin was fired. Matter of fact, there were 17 of them. Mr. Garland, it's clear Joe Biden wanted Shokin fired so he would stop looking into Burisma, where Hunter was on the board. Would you agree? All right, let's let the American people decide. Play the clip. Play the clip.
I remember going over convincing our team, or others too, convincing us that we should be providing for loan guarantees. And I went over, for, I guess, the 12th, 13th time to Kyiv, and I was supposed to announce that there was another $1 billion loan guarantee. And I had gotten a commitment from Poroshenko and from
Pay attention, sir, please.
Yatsenyuk that they would take action against the state prosecutor, and they didn't. So they said they were walking out to press conference. I said, no, I said, I'm not going to, or we're not going to give you the $1 billion. They said, you have no authority. You're not the president. The president said. I said, call him. I said, I'm telling you, you're not getting the $1 billion. I said, you're not getting the $1 billion. I'm going to be leaving here. And I think it was, what, 6 hours? I said, I'm leaving in 6 hours. If the prosecutor's not fired, you're not getting the money. Well, son of a bitch. Got fired. And they put in place someone who was solid.
Mr. Attorney General, what you just saw there was Joe Biden in his arrogance and role as the vice president in this country saying if you don't fire Shokin, the United States isn't giving the $1 billion loan. Why would Joe Biden say that as the vice president? Why would he say such a thing? Was it policy? Was it our policy at the time? Yes or no? It wasn't. I have documents here. Interagency Policy Committee dated October 15th.
Point of information, is the gentleman ever going to let the
I'm
gentleman
on my
answer
time,
question?
pipe down. Saying Shokin had made
Time belongs to
significant
the gentleman
reforms.
from Texas.
He's made significant reforms, Shokin did. Matter of fact, John Kerry says he was impressive. And you know, within a few months after Shokin was fired, they appoint a prosecutor that said, we're not going to look into Burisma anymore. Cancel that, forget it, we're not looking into Burisma. Boom, here comes the $1 million. Joe Biden threatened the Ukrainian president and the prime minister, everybody can see it, to fire Shokin, or the United States won't give the $1 billion. If that is not quid pro quo, sir, what is? I will tell you what it is, and America agrees with me. It's bribery, and it's impeachable. Are you going to do something about it? I bet you not, and that's why you, sir, also need to be impeached. I yield back.
Time of the gentleman has expired. The chair now recognizes the gentleman from Texas, Mr. Moran.
Attorney General, you were a line assistant U.S. attorney for years and a federal judge after that. You have significant experience with the processes surrounding criminal investigations. Tell me, what's the normal process for obtaining and executing a search warrant?
You go to a federal judge, you present an affidavit which you believe constitutes probable cause. The federal judge looks at it, makes a determination of whether it does constitute probable cause. He then signs a search warrant, and it's then executed.
And what's the purpose of a search warrant?
The purpose of a search warrant is to find to find evidence of a crime for which there has to be probable cause that it's in that location.
When executing a search warrant on a location that may contain evidence of a crime, what benefits are there for doing so without notifying the putative defendant or the target of the investigation or his attorney ahead of time that execution of the search warrant is forthcoming?
Sometimes you make notifications, sometimes you don't. If you think that the person who has the evidence of a crime is obstructing justice or is going to move the evidence or will secrete it, if you warn them in advance, then you don't give it. If you don't have those concerns, you may give advance notice.
Yeah, so in the instance of not withholding notice, you do so because sometimes they're going to actually move the evidence if you give them a heads up, correct?
It's a general hypothetical matter, yes.
And in most instances, in your experience of decades of law enforcement, have you seen that more times than not, you give a heads up to the defendant, or is it odd to give a heads up to the defendant?
I can't actually make a statistical resolution. I think it's the case that the government tries to use less intrusive methods if they can, and if they can't, use more intrusive and more emergency methods.
I agree with that, but typically when you're going to execute a search warrant, typically I think people would understand this from common knowledge, you would not actually give the heads up. Would you agree with that?
I think as a general matter, that's correct.
IRS Supervisory Special Agent Gary Shapley, one of the whistleblowers, testified that AUSA Leslie Wolf told investigators, quote, optics were a driving factor in the decision not to request a search warrant for the guest house at the Biden's Delaware residence where Hunter Biden had stayed for a time. AUSA Wolf further told the investigators that, quote, there was more than enough probable cause for the physical search warrant there, but the question was whether the juice was worth the squeeze. And she further said, quote, a lot of evidence in the investigation would be found in the guest house of former Vice President Biden, but there is no way investigators will get that approved. Now, do you agree with Ms. Wolf that optics of an investigation should be the driving factor in law enforcement decisions when investigating potential crimes?
I have to say again, as I said before, singling out assistant U.S. attorneys is a dangerous matter. The supervisor of that case is Mr. Weiss. He is the one who made decisions in that case. He is the one who can answer questions as to whether those things happened or whether they didn't.
So let's take her out of the equation then. Let's just take the statement generally. Do you believe that optics of an investigation should be a driving factor in law enforcement decisions as to whether or not to execute a search warrant or not?
The Justice Department has standards for its work, and improper considerations are not part of those. The only questions are those driven by the facts and the law.
Mr. Shapley also testified that AUSA Wolf objected to a search warrant IRS investigators requested for a storage unit purportedly containing all the documents from the vacated office of the law firm owned by Hunter Biden. Investigators scheduled a call with U.S. Attorney Weiss, who agreed that they could search the storage unit if it remained abandoned for 30 days. But immediately after the call, investigators learned that AUSA Wolf had reached out to Hunter Biden's defense counsel to tell them about the storage unit, effectively ruining investigators' chance to access potentially critical evidence. In your experience, as you said earlier, this is not the typical thing that happens, correct?
Look, once again, I don't know anything about these allegations. I don't know whether they are correct or not. These are questions most appropriately put to Mr. Weiss at the appropriate time and to be covered in his report if he thinks that's the appropriate way to resolve.
Can you conceive of a reason why Mr. Weiss or Ms. Wolf would have given a heads up to Hunter Biden's legal team that the search of the storage unit was forthcoming?
I'm not going to get into hypotheticals about this.
For somebody that was involved in the investigation at that point, who was literally delaying obtaining potential evidence in the case, do you think it was appropriate that then she was involved in the negotiation of the IRS deal with Hunter Biden?
I'm not actually following the question. I'm assistant U.S. attorneys who participate in investigation also participate in prosecutions. Is that what you're asking?
Attorney General, I appreciate your time here today, but I'm concerned that these facts are just some examples of what's been going on here where, I apologize, I know my time's out. I yield back. Thank you for your time.
Time of the gentleman's expired. The gentleman from Maryland is recognized for unanimous consent.
Thank you, Mr. Chairman. I guess I had my 5 minutes. I would ask for the unanimous consent to offer some exhibits. First, I would offer
Without objection.
District Attorney Bragg's March 31, 2023 letter in response to the committee.
Okay.
I would offer the letter from Attorney Abby Lowell, Hunter Biden's attorney, to the Committee of Judiciary Oversight and Ways and Means dated September 14, 2023, and its attachments.
Without objection.
I would offer the letter from Ms. Willis to the chairman on September 7, 2023.
Without objection.
And I would offer this article from CNN, Annie Grayer, top IRS official, latest witness to dispute allegations from whistleblower on Hunter Biden tax case.
Without objection.
Thank you, Mr. Chairman.
You bet. The gentlelady from Wyoming, Ms. Hageman. We got.
We have been investigating very serious charges made about your department and other elements of the Biden administration, which allege ignoring the law to protect political allies from being held accountable for their wrongdoing. One aspect of this allegation, brought by two very credible whistleblowers from the IRS, demonstrates a strategy of delaying criminal investigation into Hunter Biden and blocking any investigations into the corruption of Joe Biden. The whistleblower testimony notes that U.S. Attorney David Weiss in November 2022 allowed the statute of limitations to expire, even though Hunter Biden's attorney had already agreed to extend the statute on the 2014 and 2015 charges, which charges included an attempt to evade or defeat taxes and the fraud and false statements related to the $1 million that Burisma paid to Hunter Biden while his father was vice president. During a recent transcribed interview with the committee, FBI officials from the Baltimore field office refused to answer questions about the expired 2014 and 2015 tax charges because they were allegedly part of a, quote, ongoing investigation. Are the tax charges related to these years, in fact, part of an ongoing investigation?
Again, I have no familiarity with the details of this particular investigation.
So you don't know one way or the other?
That's right. I left it up to Mr.
So how are
Weiss.
charges for which the statute of limitations have already expired part of an ongoing investigation?
Again, I don't know anything about this case.
So why would charges that have already expired because of the statute of limitations be part of an ongoing investigation?
To answer in the hypothetical, because I don't know the facts, often charges from previous times are used as part of an ongoing investigation to inform information about intent, about patterns and practices.
For other investigations? So are there other investigations into Hunter Biden where this information may become relevant?
I think it's a matter of public record that there is a tax investigation of Mr. Hunter Biden with respect to other years. I don't
Beyond the
think
2014 and 2015?
beyond the ones that are that you were referring to. I think
Mr. Garland,
Mr. Weiss has already said that during the plea proceeding.
Okay, Mr. Garland, is it standard operating procedure in your Department of Justice for prosecutors to allow the statute of limitations to expire on very serious crimes when the potential defendant has already agreed to an extension?
So there, as I said before, there's no standard operating procedure here. This is
maybe there should be.
Well,
if this is an oversight hearing, maybe there should be. Maybe you should adopt standard operating procedures to avoid this kind of a circumstance. Would you agree?
No.
Okay.
Because it's left
According
to
to
the
one of the
discretion
IRS,
of...
you've answered my question, thank you. According to one of the IRS whistleblowers, quote, the purposeful exclusion of the 2014 and 2015 tax years sanitized the most substantive criminal conduct and concealed material facts, end quote. How can Americans trust an investigation run by a special counsel who, by allowing the statute of limitations to expire, irreversibly, quote, sanitized the most substantive criminal conduct and concealed material facts?
The prosecutor in question is an experienced veteran career prosecutor who was appointed by
And we have no reason to trust him, do we?
by President Trump.
Okay. How much in terms of taxes would Hunter Biden have owed on the $1 million he was paid by Burisma?
Well, as you can imagine, since I don't know anything about the facts of the case, I can't answer
Probably
that
about
question.
$400,000. Isn't that right? I mean, you can do the math. You know the tax code.
I don't know anything about the facts of this case, so I'm not able to do the math to apply it to
And
facts
by
I
failing
don't
to
know.
pay the taxes on those ill-gotten gains, what would the typical penalty have been, for example, if it was someone who didn't have the last name of Biden or a D behind their name?
I'm sorry, these are all questions you'll have to direct to Mr. Weiss, and that Mr. Weiss will address in his final...
By allowing the statute of limitations to lapse, did Mr. Weiss effectively gift the tax money Hunter Biden owed for the 2014 and 2015 tax years to Mr. Biden?
To say again, the decisions about whether in this area and whether these allegations are correct are ones that Mr. Weiss will be able to answer.
Mr. Garland, one of the things you have done over and repeated over and over and over again is that to point out that Mr. Weiss was appointed as U.S. Attorney by President Trump, as though that somehow inoculates him from criticism by us. Is that really how this game is played? That if someone is appointed by a Republican, then they're supposed to be on the Republican team? Or if they're appointed by a Democrat, they're on the Democrat team? You were appointed by Mr. Biden, weren't you? Are you on the Democrat
Let
team?
me just be clear. The point of that he was appointed by a Republican counteracts the claim that this was a partisan decision to benefit Democrats.
He remained as a member of the Department of Justice.
Mr. Chairman,
under you.
Mr. Chairman.
Time of the gentlelady has expired. The gentleman from Maryland is recognized again for a unanimous consent request.
Thank you, Mr. Chairman. I want to offer into evidence the testimony or segments of the testimony of Thomas Sobocinski, dated September 7th. It was taken here and before this committee. Goes to the deconfliction issue with respect to Hunter Biden's security detail and the search warrant
Without objection.
executors. Thank you.
Chair now recognizes the gentleman from California.
Good afternoon, Mr. Attorney General. Do you believe Christopher Wray is a competent director of the FBI?
I think Mr. Wray is a person of the highest integrity, for whom I have great admiration, who has extraordinary experience, both as
Thank
a
you.
career
And so you
prosecutor.
certainly don't think he would knowingly give false testimony to this committee, do you?
I am sure that he would not.
Are you aware that Director Wray, a couple of months ago in sworn testimony, implicated you in a sweeping abuse of power?
I doubt he would characterize whatever he said in that way.
Well, he testified about the school board memo that you issued on October 4th of 2021, in which you mobilized federal law enforcement powers against American parents. Now, of course, you didn't put it quite like that. Instead, you found a pretext, which is stated right here in the first line of the memo. In recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence against school administrators, board members, teachers, and staff. What was your basis for making that claim?
I will say again, as I've testified numerous times in response to exactly the same question, that I saw numerous reports in the press of violence and threats.
You saw reports in the press, and so you decided to instigate a nationwide law enforcement initiative?
If I may be permitted to answer the question.
Please.
Numerous reports in the media of violence and threats of violence against school personnel of all kinds.
Did you consult with the FBI director?
We received a letter from the National Association of School Boards reporting.
Yes, that letter contained anecdotes. It didn't contain data of an increase. Did you, yes or no, consult with the FBI director before issuing the memo?
I don't believe I spoke with the FBI director, no.
Why not? Why wouldn't you consult with the FBI director?
Because the purpose of the memo, as is very clear from the memo, is to ask the FBI to assess the situation, to hold meetings, and to determine whether this was...
Mr. Attorney General, you started with a conclusion that there was an increase in threats. Now, if you had bothered to consult with the FBI director, here's what he would have said. This is from his sworn testimony, that he was not aware of any such evidence. So my question to you, sir, sitting here today, is can you substantiate your claim that there was an increase? Of course, there will always be sporadic criminal activity in all quarters of society, but your claim was there was an increase. Can you substantiate that sitting here today?
I can substantiate that by the reports in the press of violence and threats of violence and by the letters sent by representatives of thousands.
That's a no. You're giving us anecdotes. I'm asking you if you had data. You also said in your memo that you were committed to using the department's authority and resources to discourage these threats, identify them when they occur, and prosecute them when appropriate. Were there any such prosecutions?
The emphasis should be there on when appropriate, and there were no such prosecutions, and that's good news, not bad news.
There were no prosecutions, and in fact, Director Wray said there were no arrests, there were no charges. So you have no data to show us that there was any increase. You didn't even bother to consult with the FBI director, and then there were no resulting prosecutions, even though you said that they were coming. So I have to ask you now, in retrospect, was there a compelling law enforcement justification for the memo?
I think you're mischaracterizing the memo. The purpose of the memo was to hold meetings, to open lines of communication with state.
So is that a no? Yes or no? Was there a compelling law enforcement justification for the memo?
I believe there was a reason to ask for those contacts to be made with state and local law enforcement.
Well, the FBI director disagrees with you. When I
that's
asked
not what the FBI director said.
Look at it right here, Mr. Attorney General. When asked, do you have any reason to dispute the conclusion that there was no nationwide law enforcement justification? He said he didn't.
Either he didn't see the reports or he didn't see the National
This is a
Association of
transcript. I've
Schools.
sent you this transcript, Mr. Attorney General. So my question is this. Will you retract the memo, and by that I mean issue a formal document to the effect that it is no longer operative?
I will not, because there was absolutely nothing wrong with the memo, as I have testified several times already.
Even though your own FBI director says there was no justification for it, you will not retract it?
The memo is mine. It's my decision whether it's necessary to make assessments like this, and I asked the Bureau to make these assessments, and the other...
Are you familiar with the concept of a chilling effect?
I'm sorry, I didn't...
Are you familiar with the concept of a chilling effect?
I'm very familiar, and that's the very reason...
How would you define a chilling effect as it relates to First Amendment
jurisprudence?
jurisprudence?
That is the very reason why the second sentence of the memo
Please tell me what you consider to be the definition of a chilling effect.
That memo has no chilling effect.
I didn't ask you your opinion on whether the memo has one. I asked you what is a chilling effect.
I'm telling you that the second sentence of that makes clear.
I've read the full memo. I'm asking you, what do you define a chilling effect as?
A chilling effect is when people's exercise of First Amendment rights are chilled by coercive activity by the government, which did not occur here.
So here we're dealing with moms and dads.
Mr. Chairman,
You and I
point
are
of
public
order
officials.
with respect to the time?
Yeah.
Point of order?
The gentleman's time has expired, but it was a pretty darn important question when the Attorney General of the United States can't define what a chilling effect is, so I thought I would let it go a few seconds.
The Attorney General did define what a chilling effect is and said it didn't occur here.
I don't think he defined it, he just dismissed it. The gentleman's time has expired. I thought it was a very important 5 minutes. We now recognize the gentlelady from Florida for 5 minutes.
Good afternoon, Mr. Attorney General. I'd like to return to the earlier discussion about FISA process and the fisc. A number of the members of this committee and of my community are gravely concerned about the well-documented abuses of the FISA process and within the fisc proceedings. In declassified opinions from the fisc in 2018 and 2019, the presiding Judge Boasberg admonished the FBI, stating there still appears to be widespread violations of the querying standard by the FBI, and that there appears to be a fundamental misunderstanding of some FBI personnel about what the standard reasonably likely to return foreign intelligence information means. Mr. Attorney General, what measures has the FBI instituted since that time to ensure that these abuses are stopped?
So we're talking about FBI FISA Section 702?
Yes, sir.
Which is a central part of our ability to find out what foreign nation states, foreign terrorists are trying to do in the United States. I read, when I first came into the Justice Department as Attorney General, I read the opinions you talked about, and they deeply concerned me. And I agreed when I looked into it that there was a misunderstanding by operators as to, and analysts as to what the query standard were. So one of the very first things I did was send a memo to the FBI directing that the way in which the Justice Department, and particularly the FBI, did the querying be examined and that corrections be made. This was an extension of a memorandum that Attorney General Barr had likewise, after he read similar concerns, sent to the FBI at the end of 2020.
And Mr. Attorney General, in addition to other things, the ultimate adjustments included additional attorney oversight, requiring FBI users to affirmatively opt in to search the 702 database, updated guidance and training, and enhanced approval requirements, correct?
Yes, ma'am. All that's true, and the consequence was a 93% drop in the number of U.S. person queries.
Nonetheless, Mr. Attorney General, you would agree, would you not, that there are continued needs to review, analyze, and make additional improvements and safeguards to ensure that we don't continue seeing these abuses?
I do agree.
In fact, in recent weeks, we saw even President Biden's Intelligence Advisory Board make recommendations that we continue to revise 702 oversight and restrictions, including a recommendation to direct the DNI and the Attorney General to research potential technological enhancement to the current oversight framework. Tell me, what technology might modernize and improve oversight of the 702 process?
One of the technologies that has already worked very effectively is to change this from an opt-out to an opt-in set of queries. So you have to, first of all, indicate that you are looking at 702 and not just across the board of the FBI holdings. You have to have a drop-down window which explains why you are going to do this. It's easy for us.
Does that window require the user to input narrative text?
That's right. That's right.
All right. Thank you, Mr. Attorney General. Are there other technology-specific changes that you would recommend?
Well, I'd like to consider that more. There are various kinds of auditing programs using technology. The National Security Division of the Justice Department has done some of that. The FBI, actually at the request of Attorney General Barr, began an auditing program like that. FBI Director Wray, who also agrees that these kind of non-compliance shouldn't continue, put that auditing program into effect within the Justice Department.
Thank you, Mr. Attorney General. I yield the balance of my time to the chairman.
gentlelady for yielding. Mr. Garland, in David Weiss's letter to Senator Graham on July 10th of this year, he says this: I was assured that I would be granted special counsel authority if it proved necessary, and this assurance came months before the October 7th, 2022 meeting referenced throughout the whistleblowers' allegations. How was that assurance given and who gave it?
I'm sorry, I think he was talking about 515 authority. Is that what I'm reading the letter now. He's not talking about special counsel authority. It says that I was assured.
515 authority, okay.
Yeah.
Same difference.
Yeah.
Well, not same difference, but same fundamental question.
I understand your point, yeah.
He's making the point that he was assured that this was, he could get this status, and that status came, that assurance, came before October 7th, 2022. How was that assurance given and who gave it?
Yeah, I made that clear in my direction, and that was transmitted to him.
So you told him that back before October 7th that he would have?
I'm not going to get into exactly the deliberation of the department, but
There's three simple questions. How was it given? Who gave it? When was it done?
Yeah, I understand. I gave a direction from the beginning that he would be able to bring a case whenever, wherever he wanted to. That direction he heard, obviously, and he confirms that here.
I went a little over time, so I told the ranking member I'd extend to him a few seconds or minutes if he wanted to say a few more things or ask a few more questions, and then we'll...
Thank you. Let me just ask the Attorney General. Mr. Attorney General, you've been asked many questions here which you were not permitted to answer. People asked the question and just asked another question, didn't permit you to answer. Is there anything you'd like to say in answer to anything that you think should be made clear or added?
Look, I'm grateful for the opportunity. I just, again, I want to assure the American public and this committee that the Justice Department follows the rule of law. It enforces the law equally without regard to persons and without regard to parties, and that we do the best we can to follow the facts and the law.
Thank you.
Mr. Attorney General, we appreciate you being here, and the committee maybe have to do something official. I guess anyone who wants to add something to it, they can submit that for the record. With that, the committee is adjourned.
Thank you.